system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free.
Justice Watchers, before we begin, I want to make this absolutely clear. The following broadcast contains public domain courtroom footage, commentary, and legal analysis. This content is presented under the Fair Use Doctrine as defined by 17 U.S.C. 107 and is protected by multiple Supreme Court rulings, which you see below. This stream is transformative, educational, and journalistic in nature. It includes original commentary, trial breakdowns, legal interpretation, and critical analysis, not raw redistribution. We do not claim ownership over any public domain footage, and all use is strictly within legal bounds. If you're watching this content, you're engaging in a protected, transformative experience, grounded in law, never in speculation. And if anyone has a problem with that, take it up with Campbell, Brady, Miranda, and Irvin. Remember, guys, justice always works better when we watch. So keep watching. See you in the courtroom.
number 2022-5250, State of Florida versus Lawrence Dority, State.
Michael Smith, the state.
Defense.
Harold D. Thompson on behalf of Mr. Dority. Good morning, Your Honor.
Morning. I'll note that Mr. Dority is present, dressed out in civilian clothes, and he's not shackled. He's out of custody. All right. When we stopped yesterday, we had finished with the jury selection. I did the preliminary instructions. We were going to resume the trial this morning with you all each making your opening statements and then proceeding with the witnesses. I just need to know whether or not during the opening statements, Mr. Thompson, you intend to concede any element of any crime or any lesser included offense and make sure that your client is on board with that strategy.
Yes, Your Honor, we're going to concede to the fact that this was a shooting, and of course, this is a case of self-defense, so we have to admit that that was actually done.
All right. Mr. Dority, you understand that's what your defense is?
Yes, Your Honor.
And you're in agreement with that?
Yes, Your Honor.
And you've discussed that with your attorney?
Yes, Your Honor.
Okay. Anything else that I need to address from the state?
Nothing from the state.
Defense?
Nothing from defense, Your Honor.
All right, then let's go ahead and bring our jurors back in. All right, everyone have a seat. Good morning, ladies and gentlemen. Welcome back. I trust that you all complied with the instructions I gave you yesterday. You did not do any research, looking up of any names, maps, or doing any investigation of your own reference this case. Is that correct? All right. When we stopped yesterday, we had done the jury selection, and I had given you the preliminary instructions. So we're now going to start with the opening statements of the attorneys and then start moving into the witnesses' testimony. So at this time, the attorneys for the parties will have the opportunity to make their opening statements in which they may explain to you the issues in the case and give you a summary of the facts that they expect that the evidence will show. State wish to give its opening statement at this time?
Yes, Your Honor.
You may do so.
Thank you, Your Honor. Please report. On May 9th of 2022, this defendant shot and killed Adreian Payne. And you're going to hear the evidence in this case, and it's going to show that this defendant was not acting in self-defense. He was not standing his ground. He arrived back to his house at about 1:30 a.m., and he saw the victim So you're going to hear through the witnesses and evidence in this case that the defendant was driven home that night about 1:30 a.m. by his father. He had been in an argument with his girlfriend, Tatiana Mesa, and they were at a family party at the defendant's father's house. You're going to hear that Tatiana Mesa, the defendant's girlfriend, called her best friend, Tara Walker, who was the victim's girlfriend, and asked if she could come over to the residence. Tara Walker speaks with her boyfriend, the victim in this case, and he decides to come to the residence or the area of the residence as well as backup. They all get there. Well, I guess the defendant arrives before Tara Walker, but she arrives shortly after, and the victim is already in his vehicle, parked on the street when he arrives. So the defendant had previously known the vehicle, as you're going to hear in the evidence, and he goes up and exchanges words. He's upset. You're going to hear from Tara Walker that the defendant appeared to be intoxicated at the time. Again, he didn't drive himself to his home. His father had driven him to his house that night. And, there's words exchanged, but that's not the point that the shooting happens. He takes the time, he goes inside, and he arms himself with the firearm. Now, you're going to hear from the medical examiner in this case, Dr. Marie Hansen, and she's going to tell you that the cause of death was the gunshot wound that went through the arm and the torso in this case, and that the manner of death was determined to be homicide. You're going to hear from several witnesses in the case, the primary one being Tara Walker, who was present and witnessed the shooting. And she's going to let you know, as I said, that the defendant appeared to be intoxicated, that he was upset, that he was belligerent. And I expect that you're also going to see some surveillance footage in this case. Now, the surveillance doesn't capture the incident itself, but there's a camera that's near a neighbor's camera that you can hear the shooting itself on the surveillance footage, and you can see the aftermath. And on that footage, you're going to be able to hear Tara Walker pleading with this defendant. Don't take your gun out. Don't take your gun out. We were called here. Don't take your gun out. You're going to see the defendant doesn't listen. He takes his gun out, he takes aim, and all in this moment he shoots the victim and kills him. Now, after that, you're going to see Tara Walker run to the area where the surveillance camera is located, and you're going to see the defendant's son, Dority, is running with her, and then ultimately the defendant comes out and calls his son into the house. Now, you're going to hear from Tara Walker, and she's going to tell you the victim didn't have a weapon, that he didn't threaten a weapon. The evidence in this case will be clear. This is not a case of self-defense. This is not a case of someone standing their ground. As was discussed in jury selection, in a self-defense or stand your ground situation, the facts matter. And the facts in this case are not someone defending themselves. They're someone being the aggressor, taking aggressive action, arming themselves, and committing a murder. And once you've heard the evidence in this case, we'll ask that you convict. Thank you.
Mr. Thompson, does the defense wish to give an opening?
Yes, Your Honor. May it please the court?
You may.
Good morning, ladies and gentlemen. How you doing today? Yeah, we just get right into this. This is not a complicated case. This is a very simple case. Okay? This is a case about self-defense. And not just self-defense of oneself, but we're talking about self-defense of one's family. Okay? Please pay close attention to the facts in this case. Every fact is very important. May 9th, 2022, Lawrence Dority was celebrating Mother's Day with his family at his father's house, not very far from where this incident occurred. Okay? When he decided to leave, his father drives him home. Okay? Mr. Larry Dority is the driver, Lawrence Dority is a passenger, and his 10-year-old son is a passenger in the backseat compartment of his truck. Unknown to him, unexpected, He arrives home. He observes a black Chevy, blacked out tinted window Chevy now parked outside his car. Lights, headlights on, car running. Okay? Out of concern, he starts to walk over to the car. And he starts to realize this car looks familiar to him. He believes it's the car of his long-term friend, lady friend, Sarah Walker. Evidence will show this is the car that she has been driven for months. It must be 6 months at a time. Mr. Dority didn't know that was her car. He didn't know that was a boyfriend's car. He walks up, and then the tinted window rolls down. One can't see inside his car. It's 1:30 in the morning. It's dark out. Window rolls down. Mr. Dority asks, "Why are you here?" You want to know what happens next? Evidence will show that a 6'8", at least 6'8", according to the medical examiner, is 80 inches tall. Just like 6'8", now she's tall. Steps out of the car, wingspan of 7 foot. With a threatening posture. Steps out. I was smoking. What you want to do? What you want to do? Mr. Dority immediately retreats into his home. Gets his firearm. Evidence will show that he's a concealed weapon permit holder. Evidence will show he didn't go and look for trouble. Trouble came with him. Right? His son is outside. He can't even make it into the house stage. He walks back out. But before that, he's still asking, "Why are you here?" You need to leave. Guess what happened next, ladies and gentlemen? As Mr. Dority, after being threatened, walks into his home. He comes back out, and instead of Mr. Payne, the first thing is Mr. Payne. His name is Adreian Payne. Mr. Dority didn't know that. He only knew that somebody named Adreian. He didn't know him personally. He didn't know him at all. Right? As he comes back out, not only did Mr. Payne not leave, but he pulls the car up closer to his home. So he had the opportunity to leave. And the evidence will show that his girlfriend, Sarah Walker, actually told him to leave. She had arrived at the tail end of the verbal altercation. The evidence will show she wasn't even present when Mr. Dority approached to ask him to see who he were. You heard testimony that she's going to say she's on the phone. She would admit to you that she told him not to come to the house. He did it anyway. The evidence will show he didn't even know where Mr. Dority lived. He circled around the neighborhood to find, he found Mr. Dority's car. He was familiar with it, safety pins or whatever reason. Right? Mr. Dority comes back out, asks him to leave again. Not just that, "Why are you here?" Simultaneously, as Mr. Payne reaches, Mr. Dority fires one shot, not to kill, but to repel the break. The evidence will show that bullet pierced through the bicep into his chest cavity. Only then he got back in the car. He was still standing outside the car. Okay? What did Mr. Dority do next? He didn't flee. He immediately told his son to come get in the house, called law enforcement, reported to them what happened. Okay? He cooperated with the investigation. This is a case about self-defense. This is a case about defense of others. This case is very simple. The evidence would show that neither Mr. Lawrence Dority or Mr. Dority's fiance at the time invited Mr. Payne over. No one invited him over. Evidence would show that Mr. Payne's girlfriend advised him not to go, not to come. Evidence would show that the crime scene wasn't really secure. It was contaminated before law enforcement arrived. The state was even being open to admit that there was weapons in the car. Evidence would show that that weapon, that knife, was not tested to DNA. Fingerprints was not even taken in evidence. Evidence would show that Ms. Tara Walker had access to that vehicle before law enforcement arrived. You would hear evidence that no firearm was located. But there is a reasonable explanation for that. Okay? Evidence would show that. The evidence revealed the inconsistency in the state's evidence in this case. It's abundance of it. The evidence revealed lack of evidence in this case. This is a clear case of self-defense. After you've heard and seen all the evidence, we ask that you find Mr. Dority not guilty. This is the right thing to do under these circumstances. This is not a case of a gunman on the loose, shooting bystanders and innocent people. This is a man that was on his way home, minding his business. Okay? This is not complicated. This is a case about a man who was forced to defend himself, his child, and his father against a much larger, aggressive man who showed up armed and threatening him at his home in the dead of the night, 1:30 in the morning. He didn't come singing a Christmas carol. He didn't come with any sense of kindness or respect. He came with intent to intimidate and threaten. And that's what he did. Evidence would show that Mr. Dority did what any reasonable person would do in that situation. Ask, Mr. Payne, why are you here? Mr. Dority asked Mr. Payne to leave. Did he leave? No. But more importantly, why was he there? How did you even know how to get to the house? Mr. Dority was threatened by him. He immediately went in his home and protected himself and his family. Mr. Payne postured himself in a threatening manner while outside of Mr. Dority's home at 1:30 in the morning. This is a case about self-defense. This is the case that the people of the state of Florida should recognize as self-defense. This is not acceptable. He's innocent. His actions are judgment. After you heard everything, you prayed humbly and asked that you find out. Because that is what justice is.
Okay, call your first witness.
Your Honor, at this time, we would move to offer into evidence what's been marked for identification as states E, the stipulation of the parties, and ask that be published.
Any objection from this defense?
No, Your Honor.
All right, what's been marked as States Exhibit E for identification will be received into evidence as States 1 without objection.
And Your Honor, if you could publish the...
All right, ladies and gentlemen, what is in evidence now as States Exhibit 1 is a stipulation of the victim's identification. It indicates that the Assistant State Attorney, Michael Joseph Smith, and the defendant, Lawrence Alexander Dority, as well as his lawyer, Harold Dion Thompson, stipulate that the identity of the deceased in this case is Adreian D'Angelo Payne, and it is signed by all three parties. Okay? So that is a stipulated fact that you all can consider. All right, State.
Thank you, Your Honor. At this time, the state calls Garrett Morris.
solemnly swear or affirm testimony shall give shall be the truth, the whole truth, and nothing but the truth, so help you God.
All right, go ahead and have a seat for me once you get situated. Go ahead and state your full name for me and spell your first and last name for the court reporter.
Garrett Morris, Garrett Morris.
State you make, right?
Thank you, Your Honor. Good morning.
Hi, good morning.
If you could just introduce yourself to the jury.
Yes, my name is Corporal Garrett Morris. I'm with Orange County Sheriff's Office
And how long have you been with the Orange County Sheriff's Office?
for 5 years and total time in law enforcement almost 13.
Where did you work in law enforcement before the Orange County Sheriff's Office?
Volusia County Sheriff's Office.
And what is your current job duty?
Currently, I'm a patrol supervisor in our Sector 3, west side of the county.
And what shift are you on?
Midnight shift.
Okay. Did you work last night?
I did.
Okay, so have you just come straight through from that?
Yes, I did.
I want to take you back to May 9th of 2022. Were you working at that time?
Yes, I was.
What was your position then?
At that time, I was a patrol deputy in Sector 2, which is the east side of the county. And I was on midnights as well then.
And did you have occasion on that day around 1:30 a.m. to respond to 2529 Shores Drive in Orlando?
Yes, I did.
And when you responded to the scene, were you able to locate a victim on scene?
Yes, I did.
Where was he located?
So the victim, when I located him, he was in the driver's seat of I believe, a silver vehicle, and he was with his left foot outside of the vehicle and his right foot inside the vehicle.
Did he appear to be injured?
Yes, he had a gunshot wound to his chest, and he was unresponsive.
Was anyone else near the victim when you arrived?
Yes, the defendant's father was near the victim, and so was the victim's girlfriend.
And what happened from there once you arrived, located the victim, and realized he had a gunshot wound? What did you do?
At that point, I put on my gloves and I got him out of the vehicle. The defendant's father assisted a little bit, and then I started CPR.
And you started CPR once he was out of the vehicle on the ground?
Yes, I pulled him out of the vehicle into a flat, hard surface, and that's when I began CPR.
Now, as part of anytime you're going to perform CPR and walking into an unusual situation, is it part of your protocol to check for weapons?
Generally speaking, yes. Whenever, if I were to respond to a call where maybe there was somebody who was maybe just overdosed or something like a natural causes, I may not always check for weapons, but whenever in this case there's obvious that he had been shot, I check for weapons on whoever I'm in contact with, and in that case it was the victim.
And did you locate any weapons on or about the victim's person?
No, I did not.
Now, at some point, did fire rescue arrive and take over, I guess, the CPR and life-saving measures from law enforcement?
Yes.
And what happened from there as far as your involvement?
After that, I just assisted in maintaining the crime scene. I put up crime scene tape and held that area around the car until our homicide and forensics units can get there.
Now, during this encounter that you've just described, were you equipped with body-worn camera?
Yes, I was.
And was that activated?
Yes, it was.
Have you had a chance to review that body-worn camera prior to today?
I have.
First, I want to show you what's been marked for identification as states composite D. It's 3 photos, or still photos from your body-worn camera. Let the record reflect I'm showing opposing counsel with the mark for identification as states D. Permission to approach?
You may.
Let the record reflect I'm showing the witness what the mark for identification as states D. If you could just look through these and let me know if you recognize them.
Yes, I do recognize them.
Are these still images from your body-worn camera?
Yes, they are.
Are they a fair and accurate depiction of what was captured by your body-worn camera?
Yes, sir.
At this time, the state offers into evidence what's been previously marked for identification as state's composite D.
Objections?
No objection, Your Honor.
It's been marked as State's Exhibit D for identification. Without objection, will be received into evidence as State's 2.
Permission to publish once more.
You may.
Publishing States Exhibit 2. All right, what are we looking at here?
That's the victim on the ground with a gunshot wound to his chest. I don't know at which point that was during the CPR, but that was those gloves are me checking his fanny pack for any weapons.
And I know you have a screen in front of you. Are you able to look sort of behind and see the screen behind you? Is that the gunshot wound that you observed?
Yes.
And then this here, is this a fanny pack that he's wearing?
Yes, it was.
And you went inside of that fanny pack?
I did.
And did you locate any weapons or anything of that nature?
No, I did not.
And then, I know it's a little bit blurry, but what are we looking at here in this still image?
That's the victim as I first found and observed him in his car.
Would this be like his leg here?
Yes.
This is inside the driver's compartment.
Yes, that's him sitting in the driver's seat, and I believe his left leg was out of the vehicle, and he was slumped backwards, unresponsive.
And finally, this still image, dark on the screen. It's in evidence. I don't know if you can actually see it here, but again, just to orient, this here area is that's the driver's seat.
I can see the steering wheel and the victim's shirt.
And there's another individual, this picture here, you can see it, you're actually holding the photograph.
I,
Is that the person that you understood to be the victim's girlfriend?
the female that was there was the victim's girlfriend.
You guys also had an opportunity to review a clip of your body-worn camera from responding to this incident? prior
Yes,
to that?
yes, I have.
Let the record reflect I'm showing the opposing counsel has been marked for identification as states C. Permission to approach?
You may.
Let the record reflect I'm showing the witness has been marked for identification as states C. Could you just take a look at that? You recommend it?
Yes, I do.
Is that a disc of your body-worn camera that we reviewed together back in June?
Yes.
Is it fair and accurate?
Yes.
At this time, state offers and evidence will contribute to marked for identification as states C.
Any objections? It's been marked as State's Exhibit C for identification. Will be received into evidence as States 3 without objection.
Your Honor, permission to publish once marked?
You may.
Now publishing State's Exhibit 3.
Have mercy. Oh, Jesus. Where's the ambulance officer?
Alright, back up.
Yes, sir.
Back up.
Oh, Lord, have mercy.
County 125.
Oh, Lord, have mercy. Oh, Lord.
Black male, GSW to the chest, unresponsive, no pulse. I'm going to try to get him out of the car and start CPR.
Yes, ma'am.
Here, come on.
No, man.
Here, grab his legs. Let me get him out. You got him? Yep. Come on, pull him.
He's not breathing no more. He was on his chest.
Okay.
With his head.
Alright, I got his head. Just pull him. Pull him away from the car. Alright, there we go. Give me the light.
I got you.
You guys gonna be able to save him?
So we're gonna try a new member. Right now I just need you to stand over on the side of the block, alright?
He was on his heart.
Yeah. Yeah, it's open.
Wow. Got nothing. There's no guns.
Oh my God. Oh my God. Oh my God. Oh my God. Oh my God.
That's that thing coming in.
And that concludes State's Exhibit 3. Corporal, did all the events we've just discussed, including your response, occur in Orange County, Florida?
Yes, it did.
I don't have any further questions.
Ross?
Good morning, sir. Good, thank you.
I'll just try to piggyback briefly off what you just testified to. Isn't it true you did not search the vehicle for weapons?
Yes, sir, it is. I did not search the vehicle.
And you just saw the video yourself, obviously. Isn't it true the right side passenger door was open?
I believe the girlfriend was standing at the right side passenger door, yes.
So it's fair to say, well, you didn't open the right side passenger door, right?
I didn't go to the right side passenger.
So that's, as far as you believe it was Mr. Payne's girlfriend who opened that door?
Objection calls for speculation.
Sustained.
You have no idea who opened that passenger side door and opened that door?
I do not know who opened that door.
All you know is by the time you arrived, that passenger side door was open, correct?
Correct.
Okay. And Mr. Payne was seated in the driver's side, correct?
Correct.
And there was no other person inside that vehicle at that time, correct?
Correct.
And you didn't search that vehicle, correct?
Correct.
You didn't search Tara Walker's, the victim's girlfriend's car either, did you?
No, sir, I did not.
I have no further questions.
Any redirect?
No, Your Honor.
And the witness be excused.
Yes, Your Honor.
All right, thank you, sir. You can step down.
Thank you, sir.
All right, state, next witness.
Yes, Your Honor. At this time, the state calls Hannah Miner. Miner.
You solemnly swear, affirm testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you God.
All right, go ahead and have a seat for me. And then state your full name and spell your first and last name for the court reporter, please.
Hannah Miner, Hannahminer.
All right, state your main inquiry.
Thank you, Your Honor. Good morning.
Morning.
If you could just introduce yourself to the jury.
My name is Hannah Miner. I'm a crime scene investigator with the Orange County Sheriff's Office.
And how long have you been a crime scene investigator with the Orange County Sheriff's Office?
Since January of 2022.
And if you could just give the jury a little bit of your background as far as training experience that enables you to hold that position.
I have a bachelor's degree in forensic science from the University of Central Florida. I also have a master's in pharmacy with a concentration in forensic science from the University of Florida. And I'm currently working on a doctorate in forensic science from Oklahoma State University. In addition to that, I am a certified crime scene analyst with the International Association for Identification.
What is the role, if you could just explain to the jury, what is the role of a crime scene investigator?
We are notified to respond out to crime scenes. We document those crime scenes with photos, notes, sometimes measurements. We'll document evidence, collect evidence, process that evidence, package that evidence, forward the evidence to its final location, whether that's a laboratory or our evidence unit, and then we will write reports on our involvement for those cases.
And do you work in conjunction with law enforcement, like detectives and things like that?
Yes, we do.
So I want to take you back to May 9th of 2022. Were you working in your capacity as a crime scene investigator at that time?
I was the on-call crime scene investigator, yes.
So it might seem self-explanatory, but if you could just sort of describe, what does it mean to be the on-call crime scene investigator?
Our office is staffed until midnight, so any calls that come in after midnight, it goes to the on-call crime scene investigator, where they will take calls from home.
And were you directed as part of your job as the on-call CSI to respond to a location at 2529 Egret Shores Drive in Orlando?
Yes, I was.
And was part of your job to document that scene?
Yes, it was.
At what time, if you recall, was it that you responded to that scene?
I arrived on scene at approximately 5 o'clock that morning.
Was it still dark outside, or had it begun to be light yet?
It was still dark outside.
Were you able to take some photos outside that scene before, I guess, the sun ultimately came up?
Yes.
And Your Honor, I've previously shown opposing counsel what's the mark for identification as states composite H. That's going to be photos. Permission to approach?
Yep.
Let the record reflect I'm showing the witness what's been marked for identification as states H composite of 6 photos. If you could just take a look at that. And
Yes.
At this time, the state offers the evidence of the proof of mark identification as to H.
Any objections?
No objection, Your Honor.
It's been marked as State's Exhibit H for identification. Will be received into evidence as State's 4 without objection.
And Your Honor, permission to publish once marked.
Okay.
Now publishing with the internet, this is Exhibit 4. What are we looking at in this photo?
That's the front door of the residence.
When you say the residence, is that what you understood to be the defendant's residence?
That is correct.
And then this photo?
It's essentially the same photo, just zoomed out a little bit to show more of the surrounding area.
And then you documenting a white truck in this photo?
Yes.
Appears to be a stop sign. Can you see that? I know you have the screen in front of you. Here's I'm circling the laser pointer. This is documenting the location for the intersection of the area where this happened.
Yes.
And that white aisle is still visible here. Is that correct?
Yes.
And where is this in location to the defendant's residence? We just saw the photos of.
If you were standing facing the residence, this is to the left.
I know it's dark. Obviously, you took some photos of the daylight as well, right?
That is correct.
It's dark in this photo, but what are we looking at here?
That is the victim's car.
In addition, another dark photo of the victim's car.
That is correct.
Now, after the sun did come up that morning, did you document the scene with some daylight photos, sort of capturing different items' location to each other?
Yes, I did.
Let the record reflect a previously shown opposing counsel what's been marked for identification as state's composite I-14 photographs. Permission to approach the witness?
You may.
Let the record reflect on showing the witness what's been marked for identification as state's composite I-14 photographs. You could just flip through these and let me know when you're done. And these all photographs that you took during the daylight on May 9th of 2022?
Yes.
Are they fair and accurate?
Yes.
At this time, the state offers the evidence of the previously marked for identification of state composite I.
Any objections?
No objection, Your Honor.
It's been marked as State's Exhibit I for identification. Will be received into evidence as State's 5 without objection.
Permission to publish once more.
You may.
That is the white vehicle that was parked in front of the residence.
When you say the resident, you mean the resident you understood as the defendant's resident?
That is correct.
And as we're looking forward in this photograph, what's depicted? Is this a stop sign that we had seen the earlier photo at night of?
Yes.
And then this vehicle, is that the victim's vehicle?
Yes.
So, sort of, it would be off screen in this photo, but like if we were to go over into this area, would that be essentially where the defendant's door would be located?
Yes.
So this would be sort of a perspective if you're standing in the defendant's car.
Objection as to leading.
Sustained.
What would this be a perspective of where you're standing?
Could you clarify the question?
Right, so where were you standing when you took this photo?
On the right side or the driver's side of the vehicle.
And did this capture the distance between the defendant's residence?
Objection, Your Honor. Leading, best evidence rule. May we approach?
No, overruled.
Does this capture the distance between the defendant's residence and the victim's vehicle?
It documents it, yes.
What are we looking at here?
That's the passenger side of the victim's vehicle?
And obviously the door is open.
Correct.
Was the door open when you arrived, or did you open the door?
Can I refer to my report?
Sure.
The front passenger door was open.
And now we're looking at, is this the back passenger door?
The rear passenger, yes.
Now, did you open this door for this photograph?
Yes.
What are we looking at here?
The front quarter panel of the victim's vehicle.
And then this is a different view of or directly into the driver's side of the vehicle.
Yes.
Now, this residence back here, this is not the residence that you understood to be the defendant's residence.
That is correct.
And then is this just another photograph with both the front doors open?
That is correct.
What were you documenting with this photo?
That's the driver's seat. There are some red stains on the piece of paper that's on the floorboard.
When you say the red stain, is that if you look at the screen behind you? That's what I'm circling with my latest one now.
That is correct.
And what are we looking depicted here?
That's the cup holder area of the victim's vehicle. There's additional red staining near the shifter.
This area here that I'm indicating with the latest one.
That is correct.
Which is a closer view of that.
That is correct.
And what are we looking at here?
That's the passenger side of the victim's vehicle.
And what's depicted in this photo?
That was a knife that was on the floorboard, kind of near the end of the seat.
And what seat was that?
The passenger seat, the front passenger seat. Another overall of the scene of the front of the residence and the two vehicles in the daylight.
So the front of the residence, you can look at this screen here. If you could just take the laser pointer, can you point out where your understanding of where the defendant's residence was? And then if you could point out with the laser pointer the location of the different. Now, in this photograph, is this here on the bottom left, that facing vehicle?
Yes, it is.
And so then if you could take a laser pointer and as best you can point out the location of the different trucks.
This is the white car that was in front of the residence.
Would it be the other side, far side of the white car?
That is correct.
And then again, this shows the white car from the previous photo.
That is correct.
And then on the right side of the photo is that the door to the residence.
Yes.
Did you actually enter the defendant's residence and document the interior of that location as well?
I did.
And let the record reflect, I've previously shown opposing counsel what's been marked for identification as states composite J. Permission to approach the witness?
You may.
Let the record reflect, I'm showing the witness what's been marked for identification as states composite J. Photos. You could just flip through those and let me know when you're done. Are these photographs that you took entering or inside of which defendant's residence?
Yes.
Are they very accurate?
Yes.
At this time, the state offers the evidence of the previously marked identification as states composite J.
Any objections?
No objection, Your Honor.
It's been marked as States Exhibit J for identification without objection will be received into evidence as State 6.
Permission to publish once more?
You may.
What are we looking at in this photo?
That's the entryway to the residence.
And then in this photo, have you stepped inside the residence?
Yes.
In this photo, are you just a little bit, I guess, further inside the residence?
Yes.
What are we looking at here?
Another photo photographing the entryway, so the way I had just come through the residence from the sliding glass door from the previous photo.
So this would be you come in, and then you turn around, and I guess you'll put the photo looking back that way, is that correct?
That is correct.
What are we looking at here?
It's another overall photo just panning from that same location back toward where I just walked through the residence.
Now, in your documentation of the residence, was a firearm located?
Yes.
What are we looking at here?
It's a photo of the kitchen area where the firearm was located inside of that drawer that's open in the photo.
Take a laser pointer and point out through the drawer that you're referring to. And then is this photograph just looking at the drawer inside showing the firearm?
That is correct.
And then what is depicted here?
That is the firearm once I rendered it safe and placed it in a firearm box.
What does it mean to render a firearm safe?
In the original photo, the slide was forward, so there's no way for me to know if the firearm was loaded or not. So in order to render it safe, I take the magazine out, which is the item on the right, and then lock the slide back to make sure that the chamber is empty so that it's safe to handle.
Is it fair to say previous to this photo, the magazine was inside the firearm?
That is correct.
Now, that firearm that we just saw the photographs of, was it ultimately collected and placed into evidence?
Yes, it was.
Let the record reflect, I'm showing opposing counsel what's been marked for identification as State B. B. Commissioner approach the witness.
Go ahead.
Let the record reflect, I'm showing the witness what's been marked for identification as State B. If you could just take a look at this and let me know if you recognize that as the firearm that you collected from it.
Yes, it is.
And that was placed in evidence by you.
Yes, it was.
At this time, the state offers in evidence what's been previously marked for identification as State B.
Any objections?
No objection, Your Honor.
It's been marked as State for identification without objection. Will be received into evidence as State 7.
Your Honor, permission to have the witness get off the stand and publish to the jury?
You may.
Then I can step off the stand and have you, later in the course of your duties as a CSI in this case, were you tasked with collecting from the medical examiner a projectile or bullet recovered from the victim in this case?
Yes.
Let the record reflect, I'm showing opposing counsel what's been marked for identification as States A. Thank you. Permission to approach.
You may.
Let me know if you can tell who's marking or if you need to open this. But I'm showing the witness what's been marked for identification as State A. Do you recognize this?
Yes.
And how do you recognize it?
The label has the case number, the location collected, a description that says sealed container labeled bullet from right abdomen. It has my name and EID on it and my initials and date that I sealed the item on the tape.
And is that the bullet or projectile that was recovered from the autopsy?
Yes.
And at this this time, the state offers into evidence what's been previously marked for identification and states A.
Any objections?
No objection, Your Honor.
What's been previously marked as States Exhibit A for identification without objection will be received into evidence as States A.
Beyond what we've discussed, did you document any further scenes in this case?
No,
Did you have any further involvement?
just my response to the medical examiner's office.
And did all the events, all your investigation occur at the residence located in Orange County?
The initial call-out response, yes, was only at the residence.
I don't have any further questions. Thank you.
All right, Cross.
Yes, Your Honor. Good morning. How you doing, Investigator Minor? How you doing today? Just briefly, I want to ask you some follow-up questions. How long you said you've been a crime scene investigator?
Since January of 2022?
January of 2022.
Correct.
And this incident occurred in May 2022, correct?
Correct.
So about 4 months. At the time of this incident, you had been a crime scene investigator for 4 months, correct?
Correct.
Okay. Is it fair to say this was your close to like your first actual one in the field solo?
No, it was not.
Okay. Were you supervised by anyone?
Yes, I was.
Okay. When you obviously crime scene investigate, do you guys wear body camera footage? You don't do stuff like that, do you?
We do not.
And you arrived at this scene about 4 hours after the incident actually happened, correct?
I don't know what time the initial incident was reported.
Is that not something you would put in your report or something you think relevant for crime scene documentation?
I document the time I was notified that my response was required, the time that I arrived on scene, and the time that I cleared the scene.
Okay, what time were you notified?
Approximately 4 o'clock in the morning.
4 in the morning. And what time did you arrive? 5 in the morning?
Correct.
And as a part of your documentation, can you tell me again what your functions are? You say you document, but just walk me back through it briefly.
We respond to the scenes. We document them with notes, photography, any other processing methods that are deemed necessary for this specific case. We collect the evidence once it's been documented. We'll process that evidence. We will send the evidence to their final destinations, whether that's a lab or our evidence unit, and then we will write reports on essentially what is our involvement with each case.
Perfect, perfect. So I noticed you said you collect evidence, correct?
That is correct.
Isn't it true it was also a knife in the car that was not taken into evidence by you?
Yes.
When you arrive on the scene, is that a part of your duties to dust for prints or try to obtain DNA? Is that part of your job?
It can be.
When you say it can be, meaning that's something that you usually would do?
It's a case-by-case circumstance.
So in a case where someone is alleged to have been murdered or shot, you notice this blood spatter in the car. Is that not a case where you would dust for prints or dust for DNA if a weapon is located in the car?
It depends on the case circumstances.
Would you consider a knife a weapon?
It can be.
So I noticed you took a lot of pictures of Mr. Payne's vehicle. Let me go back a little bit. Are you aware of the vehicle, the owners or the persons that are said to be the owners or operators of the vehicles that you took picture of?
No.
So the black vehicle, the Chevy Malibu, you don't know who owned that car or drove that car?
It was my understanding that it was being operated by Mr. Payne.
Okay. Were you aware that Mr. Payne's girlfriend had a vehicle that was on the scene as well?
No,
Isn't it true you didn't take a picture of that vehicle?
I don't know what vehicle it is, so I don't know if it's in my photos.
Not even aware of it at all, correct?
Correct.
So it's fair to say you didn't take a photo of it.
I don't know what the car is. It could be in the background of one of my photos, so I don't know.
Okay. Did you take a photo of a white Audi truck SUV?
Not to my recollection.
You took a photo of a white truck, correct?
Yes.
You took a photo of a white Mercedes Benz, correct?
Yes.
You took photos of a black Chevy Malibu, correct?
Yes.
So if you were to learn that Tara Walker, Mr. Payne's girlfriend, drove a white Audi vehicle and it was on the scene of this incident, you would agree that you did not document that vehicle?
Not to the same extent that I did the others.
Did you document a white Audi in your report at all?
In my report, no.
Had you knew of a white Audi vehicle being on the scene, would you have done that?
Depends on the case circumstances.
Okay, I want to make sure I ask you this clear because I'm not trying to trip you up. As far as your records and your reports, did you document a white Audi vehicle on the scene?
In my report, no.
Okay, thank you. So it's fair to say you don't know what was inside of that vehicle.
If I did not document it, I would not know what is inside of it.
Thank you. And just to be clear, part of your duties are to collect evidence, correct?
That is correct.
No further questions, Your Honor. Thank you.
Can you redirect?
No, Your Honor.
May the witness be excused?
Yes, Your Honor.
All right, ma'am, you can step down. All right, let's take about a 5 or 10 minute recess, and then we'll pick up with the remainder of the witnesses for the morning, okay? All right, so, ladies and gentlemen, if you can step back in the jury room, if you need to use your restrooms or whatnot, we'll give court staff a break, and then we'll come back in about 5 or 10 minutes and resume, okay? All right. All right, we're in recess for about 5, 10 minutes. address.
Yes, Your Honor. At this time, the defense would like to invoke the rule pursuant to Florida Rule Criminal Procedure 90.616, sequestration.
All right, the rule of sequestration has been invoked at this point. I've noted that none of those witnesses have been in the courtroom. You've discussed that with them, Mr. Smith.
I have, Your Honor, and I just emailed my victim witness coordinator because in a previous conversation at the bench, we were informed that this was being live streamed. So I've informed him to let any future witnesses know not to watch the live stream as well.
Got it. Thank you. All right, then have a seat. And state, you can call your next witness.
Yes, Your Honor. At this time, the state calls Marco Quintanar.
You solemnly swear or affirm testimony you shall give shall be the truth, and the whole truth, and nothing but the truth, so help you God.
Sir. All right, have a seat for me. And then, sir, go ahead and state your full name and spell your first and your last name for me.
Marco Antonio Quintanar Gonzalez. Quintanar is Quintanar. Marco, Marco.
State your main inquiry.
Thank you, Your Honor. Good morning.
Good morning.
If you could just introduce yourself to the jury.
I'm Marco. I live in the corner of where the incident happened, just a neighbor.
And you live in the city of Orlando?
Correct.
Okay. Now I want to take you back to May 9th of 2022. Did you have surveillance cameras at your home?
Correct. I had one at the garage.
Okay, what type of surveillance system did you use?
It's a Nest camera by Google.
Nest by Google?
Yeah.
And if you could just give the jurors a sort of specific location of where that camera is located.
So basically, in the entrance of the garage, just in the middle of the garage, it's pointing to the driveway towards the street.
Now, does that camera have both video and audio capacity?
Correct.
And did it capture the audio of an incident that occurred in the early morning hours of May 9th of 2022?
Yeah, that's correct.
And were you able to provide that footage to law enforcement?
Yes, I did.
How is it that you were able to access that footage?
So basically, through my phone in an app, I just selected the time and hit download and provided that to the law enforcement.
Now, for that app, do you have like a secure login that you're able to go in and locate footage from your camera?
Yeah, I mean, you have to log in with your email and password to do that.
And you were able to access the footage and then provide that footage to law enforcement?
Yeah, that's correct.
Before you provided the footage to law enforcement, did you, other than selecting specific time frame, did you edit the footage or change it in any way?
No, not at all. I just selected it and downloaded it.
Who all has access to that footage? Does anybody else have that app?
My wife.
And again, you or your wife didn't tamper with or edit the footage you provided to law enforcement in any way?
No, not at all.
Let the record reflect I've previously shown opposing counsel what's been marked for identification as states F. Permission to approach the witness?
You may.
Let the record show that I'm showing the witness what's been marked for identification as states F. Do you recommend it?
Yeah, it's the video footage recorded in CD.
And we reviewed this footage together back in June?
Correct.
Fair and accurate?
Yes.
At this time, the state offers an evidence of previously marked for identification as states F.
Any objections?
No objection, Your Honor.
What's been marked as previously as States Exhibit F for identification were received into evidence without objection as States 9.
publication. Now, you yourself weren't a witness to any incident, right? You just located the footage.
Yeah, no. At that time, we were up because I have a son that at that time was 4 months old. He wake up to be fed. So basically, we were about to get back to sleep, and we hear the gunshots. And I wasn't really sure, so I have to open the app and hear that. So, yeah. And then the next morning, an officer knocked at my door. He asked if the camera captured the moment. So I said yes, and he requested that video.
So hearing the shot is what caused you to go and look at your camera to see if it captured anything. Is that fair to say?
Yeah, correct.
All right. I don't have any further questions. Thank you.
Ross?
Yes, briefly, Your Honor. Good morning, sir. How are you doing today?
Good morning.
You stated, so isn't it true you didn't actually see the verbal altercation that transpired outside?
Yeah, that's correct.
Could you hear the altercation?
No, I mean, I just hear the gunshots, and then when I opened the app, I could hear the altercation through the video.
So you were able to hear the altercation when you looked at your video, correct?
Correct.
So you agree it was an actual verbal altercation prior to a shooting, correct?
Correct.
All right. And the videos that you provided to law enforcement, how many videos were there?
Just one.
Just one? Was it one long video, or was it, like, do you recall?
No, probably it was about a minute long.
10 minutes long?
1 minute.
1 minute long?
Yeah.
Okay. And isn't it true the video that you provided to law enforcement doesn't actually capture Mr. Lawrence Dority and Mr. Payne in any frame of the video?
No, it doesn't. It doesn't show that.
So essentially, it just shows a headlight illuminating in the area, an argument occurring, and then a gunshot, correct?
Yeah, it's basically the audio what the police was interested in.
Thank you. No further questions.
You redirect?
No, Your Honor.
The witness step down?
Yes, Your Honor.
All right, thank you, sir. All right, next witness.
Yes, Your Honor. At this time, the state calls Tara Walker.
You solemnly swear affirm testimony you shall give shall be the truth, the whole truth, nothing but the truth, so help you God.
Have a seat for me. You go ahead and state your full name for me and spell your first and last name for the full report.
Tara Helena Walker, T-A-R-A, last name is Walker, W-A-L-K-E-R.
I just need you to speak up a little bit.
Okay.
Thanks. You may inquire.
Thank you, Judge. If you could just introduce yourself to the jury.
Hi, I'm Tara Walker. I'm Adrian's girlfriend.
And what city do you currently live?
Orlando.
Now, are you currently employed?
Yes. I work at Baptiste Dentistry.
Now, I want to take you back. Do you know a person named Lawrence Dority?
Yes.
How do you know that person?
He was my best friend's boyfriend.
And who is your best friend, or who was your best friend that you're referring to?
Tatiana Mesa.
Now, over the years, first of all, how long have you known Lawrence Dority?
At that time, 15 years. About.
At that time, I assume, are you talking about the time of the incident back in
Correct, yes.
2022?
Yeah, because now it would probably be around like 18 years.
So going back to 2022, how long had you known Lawrence Dority?
15 years.
And over the years, would you say that you maybe encountered Mr. Dority 100 times more?
Yes, more.
Would you recognize him if you were to see him today?
Yes.
Is he in the courtroom?
Yes.
Can you point him out and describe something he's wearing for the record?
He's right there and he's wearing gray.
Let the record reflect the witnesses identified the defendant.
So noted.
Now, going back to May of 2022, did you know a person named Adreian Payne?
Yes.
How did you know Mr. Payne?
I was in a relationship with him.
How long had you been in a relationship with him?
5 years.
And did you have any children in common?
Yes.
How many?
1.
So I want to take you back to the early morning hours, sort of after midnight on May 9th of 2022. Did you ever go to the defendant's neighborhood in the early morning hours of May 9th, 2022? Yes. When you arrived in that area, where did you go specifically?
In the middle of the street.
What vehicle were you in?
My car. I was in an Audi Q5.
And was the area you went to, was that Egret Shores Drive area?
Yes.
And is that in Orange County?
Yes.
Now, why is it that you decided to go to that area?
Tatiana had texted me and asked me to meet her at her house in 15 minutes.
Okay. And so did you agree to do that?
Yes.
And was your understanding that she had been in an argument?
Objection as to leading.
Your Honor, can we approach? So you said you had received a call from your friend Tatiana Mesa?
A text message, yes.
And your understanding was that she had had some sort of argument with the defendant?
Correct.
And so you agreed to meet her at the residence?
Correct.
So at some point after speaking with Tatiana, did you have any kind of contact with Adreian Payne?
I did, yes.
Can you describe that contact?
He was on his way back to my house. It's Mother's Day night. He had left and he was coming back. And I told him that I was going to go to Tatiana's house to see what was going on, that she had asked me to come to her house and that she had called the police.
Your Honor, hearsay, your approach.
Hold on. All right, ladies and gentlemen, there has been an objection to the last comment that was made by the witness as it relates to the police being called. I have sustained that objection. It is not relevant to these proceedings, and you are to disregard any reference to that comment, and you are not to consider it in any way, shape, or form in reaching a verdict in this case. Understood? All right. If I could have you all step out into the hallway or into the jury room just for a brief minute so that I can have another issue dissolved or resolved with the parties, okay? We wrote it. All right, go ahead, have a seat. All right, Mr. Smith, you have a few minutes. Ma'am, if you want to step down, you and Mr. Smith are going to have a conversation. That's fine. If she wants to stay there, that's fine too.
That was in the text message. She said that she called the police. Okay. Okay.
All right, then we can go ahead and bring the jurors back in. All right, everybody have a seat. You may resume.
Thank you, Your Honor. So after receiving the text from Tatiana Mesa, you had communication with Adreian Payne, is that right?
Correct, yes.
And did you inform him of what you were doing?
Yes.
I guess, did he decide to come to that area as well?
Correct. He said he was coming off the highway and that he would meet me there.
So what happens when you first arrive at the area of the defendant's residence?
Larry, his father, is parked in the middle of the street near the stop sign, and Adrian's car is about 7 houses down, and Lawrence and him are outside of the car having a conversation.
Okay. And so you witnessed them having a conversation. What did you do from there?
I stopped in the middle of the street. Larry was standing outside of his vehicle. I rolled down my window. I lowered my phone down because I was on the phone with Adreian. And he told me to get back, that he was going to get his gun. And I was like, you know, what?
So let me stop you. Who told you to get back he was going to get his gun?
Larry.
Larry said he was going to get
Larry did, yes, correct.
Okay.
And I was like, what are you talking about, Larry? That's Adreian. That's Armani's dad. That's my boyfriend. And then he said, oh, that's a big fella. I'd never seen him before. And I was like, yeah.
And this is Larry, again, this is your understanding of Lawrence, the defendant's dad?
Correct.
Okay. So then what happened from there?
So I put the phone back to my ear. I was looking straight. I see that Adreian has his arm on top of the car. And he has one arm over the door. He's in between the crease of the door. Lawrence is standing on the side of here, the side of him. And I heard him say something like, get on, Lawrence, I'm not worried about you. Lawrence backed up. Adreian closed the door. Lawrence walked to the house, and Adreian walked over to me.
Okay. So at this point, the defendant has gone back inside the house?
Yeah, so we were about 7 houses down from his house, so he walked through the back, like on the grass, maybe around his backyard.
Okay. And then you have a conversation with Adreian?
Correct. He walks over to me. He walks in the middle. Larry is still there. He's getting into his car. They kind of just like nod heads. He gets in his car. He reverses and he pulls to the front of the driveway. Adreian's talking to me. I asked him, are you okay, babe? He said, yeah. Are you okay? And I said, yeah. Go back to your car and just pull up, and I'm going to park right here, which was like guest parking on the side of the house.
And did he go back to his car?
He did, yes.
Now, in that interaction that you had with him, did you observe him to be armed with any firearm?
No.
Did you observe him to be armed with any other weapons, like a knife or anything like
No.
that? And so, does Adreian actually go back to his vehicle?
Correct. He walks back to his car. I park my car where I say I'm going to park it. He pulls up to the spot where we were originally at, where Larry and myself was located.
So he pulled the car up to that spot?
Correct.
Now, that spot, where was that in location to the defendant's residence?
So we were in front of someone's house and across the street, and then it's the townhome. So there's one house and then their house.
Okay.
So stop sign, their house, and then his house.
And so, at some point, did the defendant come back outside of his residence?
Correct.
Are you able to estimate about how long that was? Obviously, I know you didn't have a stopwatch on you.
I know it wasn't less than 30 seconds. I mean, it had to have been like a minute and a half, maybe. It was somewhere.
At some point, did the defendant come back outside of his house?
He did.
Okay. When did you first notice that he had come back outside of his house?
So I parked my car. I walked over to Adreian. He opened his car door. He stuck his left leg out. I thought he was getting out the car. He had his hand on the steering wheel. And I said, babe, don't get out the car. I'm going to go see what's going on with Tatiana. Okay. And I turned around. I probably took about 5 steps. And then I seen Lawrence coming from in between the cars. Like there was another car and then a Mercedes, which is his car. And he had his arm under his shirt. And he came to the edge of it. I stopped. I asked him not to draw his weapon. What was he doing? His dad was asking, what was he doing, son?
Sustained.
Without getting into what anybody else was saying, what did you observe?
He came down to the end with a gun under his shirt. he took the gun out of his shirt. I asked him not to raise his weapon. I started to yell his name, Lawrence. And then from there, he asked us he asked, "Why are you here?" He asked a couple times, maybe like 2 to 3 times. And I tried to explain to him, Tatiana asked me to be here.
Okay, and so at some point after he's walked out, he's now taken his firearm out.
Yeah.
And where was he when he had the firearm out? How far was he from Adrian's vehicle?
Not far. He was at the end of their street. I mean, at the end of the grass, the neighbors. So I don't know how to explain it unless I show you.
Walked down. Let me have a photo here. Your Honor, this is in evidence of state composite 5. Are you able to see my laser pointer on the screen? Yeah. Okay. So I'm going to have you take the laser pointer if you could.
Okay.
And then you hit this button here.
Okay.
And then just point at the screen where Adrian's vehicle is located.
I'm sorry. Right here.
Okay. Now, with the laser pointer, if you could just sort of circle an area where the defendant was when he fired the shot. So he had walked a few places down from his residence. Is that fair to say?
Objection as to leading, Your Honor.
Sustained.
Move to strike.
Well, no answer has been given. You can rephrase.
So if you could just, with that laser pointer, can you circle where the defendant's residence was? Okay. And then if you could just sort of walk down with a laser pointer showing the jury where the defendant had walked to at the time he fired the shot. And is he on the grass area?
Correct. Yes.
Okay. Now, you had some interaction, you said, with the defendant as he came back out?
Correct.
And were you able to observe his demeanor?
Yes.
What was his demeanor like? Was he even-keeled? Was he upset?
It seemed like he was intoxicated.
Speculation, Your
Overruled.
He appeared to be intoxicated to you?
Correct. Yes.
Now, after the defendant shot Mr. Payne, what happened from there?
I turned around to run towards Adrian or, get to him. His dad grabbed me and spun me around and told me that I needed to run.
Your Honor, it's not offered for the truth of the matter asserted. It's direct.
We're not going to have the arguments in front of the jury either, so let's come on up.
Okay, so after the shooting, you were saying what happened next? You can continue.
I spun around, turned around to get to Adreian. Lawrence's father grabbed me, spun me around, and told me I needed to run, to grab Havian and run.
Did you do that?
I did. I ran over I walked over, I tried to run, my legs felt like bricks. I went to him, I opened the car door, he jumped into my arms. He was already crying. I put him down because I couldn't carry him, and I told him to run. So we started to run. Larry ran over to Adreian.
Okay. Now, let me stop you there. So you run after this, and you run a few houses down. Is that fair?
Yes.
Have you had an opportunity to see some surveillance footage that shows you after sort of running down, also that captures the audio of the shooting?
Yes.
Let the record reflect I'm showing opposing counsel with been marked for identification as State G. Permission to approach? Let the record reflect that I'm showing opposing counsel with been marked for identification as State G. Do you recognize this?
Yes.
And how do you recognize it?
My initials.
Is it a fair and accurate depiction of what was captured in it?
Yes.
At this time, the state offers an evidence that was previously marked for identification as State G.
Any objection?
No objection, Your Honor.
All right, what's been marked as State's Exhibit G for identification without objection will be received into evidence as State's 10.
And Your Honor, if I could just have a moment to set up the player. Now publishing States 10. go back through that and ask you a few questions about some of the voices and things that we're hearing on the video. Okay.
Okay.
So that voice that we hear there, is that your voice?
Correct, yes.
And what are you saying there?
Do not pull your gun out.
Now I want to stop there. You said something after "do not pull your gun out." What was it that you said?
Lawrence? I didn't. Me?
We hear some yelling there. Who is yelling?
Larry.
Larry would be
His father.
father. So, are these two individuals, and I'll have to look at the screen behind. Who is this? And then who is this person?
Get in the house! Come in! Come in! Go in the house! Go in the house! Go in the house! Come in! Come in!
We hear a person saying, "Get in the house." Whose voice is that?
Lawrence.
The defendant?
Correct.
Come here! Oh my God, please! Right now! Please help me! Help me! Help me!
I'm going to pause here. If you could look at the screen behind you. You see my laser pointer? Who is this person?
Lawrence.
That's the defendant.
Correct.
Help me! Please, please! I don't know the address! I don't know! He shot him! He's gonna die!
That is State 10. Statement now published, what's already been entered into evidence of State 9. So the voice that we hear sort of at the beginning of that, and I'm going to turn it back up, but as much as I can. Is that your voice again?
Correct, yes.
And is that sort of a different camera that caught sort of the same audio or similar audio to the other surveillance that we just reviewed?
Yes.
Now, obviously, on the video, On the video that we just watched, we saw you sort of run by to that neighbor's residence.
Yes.
After that video ends, what do you do?
I run down a little further, and I'm banging on doors.
At any point, did you go back to, how long after that would you estimate that law enforcement arrived?
Oh, I don't know. It felt like forever.
At any point, did you go back to the area where Adreian was located, where his vehicle was located?
Yes, I heard Larry.
I don't want you to get into anything that anybody else said. I just want you to tell me what you did.
I ran back.
Okay, so you went back to that vehicle?
I did.
Okay. And then what did you do when you got back to the vehicle?
I went to the driver's side. I put my keys on top of the car, and I looked to see if he was alive.
Okay. Did he appear to you to be alive?
No. So
What did you do from there?
I ran around to the passenger side. I tried to readjust his head because he was leaning over into the middle with his head up, and I needed to fix him so I could try to do compressions because I couldn't get him out the car.
Okay, and then so you go around the passenger, you open the passenger side door.
I do.
And then what happens from there after you try to reposition his head?
I start the compressions. I'm telling Larry
Sorry to stop you. You're trying to do the compressions in the vehicle?
in the vehicle. We can't get him out.
Okay. Then what happens?
I tell Larry, you have to help me. He's not breathing no more. And he starts screaming. He leans down and he starts doing them with me. So we're both pushing on his chest.
And then, so you're there with Larry. Are y'all there with the vehicle and with Adreian trying to render aid to him
Yes.
until law enforcement arrives?
Yes.
At any point, did you observe a firearm in the vehicle?
No.
Overruled. Calls for a yes or no answer.
No.
Now, let me show you a photo. This is again in evidence and states deposit 5. Do you recognize it?
Yes.
What is this a photo of?
My kitchen knife.
And is this from Adrian's vehicle, the passenger side?
Yes.
Why, if you know, was this knife there?
Objection is speculation, Your Honor, and lack of foundation.
Overruled. The question was why, if you know.
You can answer.
I put it there.
And,
I'm sorry, what was the answer?
I put it there.
and why was the knife there?
We had went to dinner before he'd left overseas.
Okay, so you had put the knife there previously?
Correct, yes.
And it's from dinner?
Yes, correct.
And had you left the knife in the vehicle?
Objection is for leading, Your Honor.
Overruled.
Had you left the knife in the vehicle?
Yes, I did.
About how long before this incident was the knife?
Maybe 4 months. He went overseas. I was driving his car. He was only home for, okay.
So about 4 months?
Yes.
And then he had been obviously not around his vehicle.
Objection is counsel testifying, Your Honor.
Sustained.
You had stated that shortly after this, he was away, is that right?
Correct.
And then how long before this incident had he been back?
19 days.
All right. So that knife that we just saw the picture of, at any point during this incident, did you see Adreian with that knife on his person?
No.
Did you ever see him threaten anybody with that knife?
No.
Now, you previously said that you didn't observe a firearm on Adreian or in the vehicle. Is that right?
Correct.
Did you, and I know this is going to seem like I'm not trying to embarrass you or anything, but did you take a firearm and hide it at some point during this incident?
Leading, Your Honor.
Overruled. It's a yes or no answer.
No.
And you remained, did you remain in the area of the vehicle until law enforcement arrived on scene?
Yes.
And at some point in the early morning of May 9th, did you ultimately speak with law enforcement?
Yes.
And did you remain on scene to do that?
Yes.
Your Honor, I don't have any further questions at this time.
Cross.
Yes, Your Honor, briefly, if I may.
Good.
Good morning. How you doing, Ms. Walker?
Good morning.
Today. I'm just trying to follow up with some things that you're just saying on direct. I'm not trying to trip you up. I know this is a very sensitive situation for you. Isn't it true that when the initial verbal altercation occurred between Mr. Dority and your boyfriend, Adreian Payne, you were not present at the scene physically?
I pulled up. I was driving up.
Isn't it true Mr. Payne was on the scene before you were, correct?
Correct.
Right. And by the time you were pulling up, you had began to hear communication that you believe was the voice of Mr. Dority, correct?
Correct. I believe him
Okay.
and Adrian had a conversation.
Isn't it true you had actually told Adreian Payne not to come to that house, correct?
Correct.
And the type of vehicle you were driving was an Audi Q5, right?
Correct.
After you told Adrian not to come, he told you, no, I'm on my way. I'm already there. I'm on the I-4, getting off the I-4. I'm on my way. I'm almost there, right?
He said he was coming off of the 408
408, I'm sorry.
and that he would meet me there.
Okay. But he didn't, in fact, meet you there. He was already there when you arrived, correct?
Correct.
At some point, when you pulled up, you previously testified that you saw Mr. Dority's father present at the scene as well, right?
Correct.
And when you saw Larry Dority, he told you, watch out, Terry, I'm about to get my gun, correct?
Correct.
This is Mr. Dority's father telling you he's about to get his gun, correct?
Correct.
Not Lawrence, right? And that was based off what he had observed prior to you arriving, correct?
Correct.
You've known Larry Dority for a while, right?
Yes.
Lawrence's dad, right?
Yes.
You're aware he's former military, right?
Yes.
So at some point during this verbal altercation, Mr. Dority walks away into his home, right?
Yes.
But before he did that, he actually asked Adreian Payne, why are you here? Right?
I can't recall, but I've said it.
You were on the scene, right?
Correct.
Are you saying you didn't hear it or you just don't remember?
He's asked him that he asked that question when he was sitting in the car behind me.
You said we were sitting in the
When he was sitting in the car behind me, he asked that question.
Who was sitting in the car behind you?
Adrian.
Behind your car?
No, I was standing in front of his doorway when he got shot. I didn't know if he was talking to me or Adrian.
Isn't it true that instead of Mr. Payne leaving, when Mr. Dority went in the house, Lawrence Dority, he moved his car up closer to the home, correct?
I asked him to.
You asked him to do that.
Yes.
But it's correct. He did, in fact, move his car closer to the home, correct?
Correct.
This is 1:30 in the morning, at least, correct?
Correct.
How tall was Mr. Payne? About five? No, he was 6'10", right? 247 pounds, correct?
I can't say 240.
Big guy. Is it fair to say he's a big guy? Okay. You aware of how tall Mr. Dority is? Lawrence, he's about 5'8", right? Right. But you also told Mr. Payne to get back in the car, right? You actually verbalized to him to get back in the car.
I asked him to go to his car and pull his car up.
So, after Mr. Dority, Lawrence Dority, fired one shot in the direction of Mr. Payne, it's your testimony that Larry Dority, Lawrence's father, told you to run, right?
Yes, sir.
We previously saw that video that was just showed. It wasn't just you running, right? It was a little 10-year-old boy running as well, right?
Correct.
So it's fair to say it was Mr. Doherty's, Lawrence's son was outside during this incident, right?
He was inside of the vehicle.
He was outside the house, correct?
Correct.
Okay. And let's get this straight. Did Mr. Adreian Payne live there?
Where?
At the location he was supposed to meet you at?
No.
Did he live there? Okay. Did Tatiana Mesa, Mr. Doherty's girlfriend, did she invite him over there?
She invited me.
Did she invite Adreian Payne there?
No, she invited me.
Thank you. You stated that it took some time for law enforcement to arrive at the scene, right? It felt like forever?
Correct.
At some point, you walked over to the passenger side of this Chevy Malibu and entered the vehicle, right?
Correct.
And it's your testimony that you entered it to straighten up Mr. Payne's head?
Correct.
You said you started compressions as well?
With Larry, yes.
At some point, isn't it true that you left the scene at some point, but your brother picked you up, right?
I left around 7 a.m. after they told me I could leave.
Before 7 a.m., you had left the scene too, correct?
No.
You never went to Mr. Larry Doherty's house?
I was after 7 a.m.
That was after 7 a.m.?
Yes.
Your car was still at the scene?
Correct.
Your brother came and picked you up, right?
At 7 a.m.?
That's how you left the scene. Your brother came to pick you up?
Yeah, he came at 2 o'clock in the morning.
He came at what time?
2 a.m.
He came at 2 o'clock in the morning?
Mm-hmm.
And you didn't leave till 7?
Correct.
So your brother was on the scene for 5 hours with you?
Correct.
What kind of car did your brother drive?
At that time,
Yes, ma'am.
BMW?
Wasn't it true someone else came to the scene as well? Was it your father?
Correct.
Around what time did he arrive?
3, maybe?
Okay. This was after you had entered the vehicle to straighten Mr. Payne's head, correct?
Correct.
And although you had a vehicle, an Audi, right? You left with your brother, right?
Correct.
And this kitchen knife that was in the car, it was in that vehicle for 4 months, you said?
Yes, roughly.
Because you used to drive that vehicle, right?
Correct.
So that would explain how Mr. Dority may have been somewhat familiar with the vehicle at some point.
Correct.
I know this sounds like a very ignorant question, and pardon my ignorance, but it was fair to say you love Mr. Payne, right?
Correct.
You wouldn't want him to have a bad name, would you?
No.
It's true, you would do anything to protect his name, right?
What do you mean by anything?
Is that fair? Would you?
No, not necessarily.
No further questions, John.
You redirect?
Yes, Your Honor. So at any point from when you first arrived on scene and you saw Adrian's vehicle up until the moment he was shot, did you ever observe Adrian set foot on the defendant's property?
No.
Now, by the time the defendant came back out with the firearm in this case, was Adrian already back in his car?
Correct.
And at the time, in the moments before Adrian was shot, did he have a weapon?
No.
And did you witness him make any threats to the defendant at that time?
No.
And were you in a position that if he would have made such threats, you would have heard them?
Yes.
I don't have any further questions.
All right, step down.
Yes, Your Honor.
All right, thank you, ma'am. All right, ladies and gentlemen, we're just a little bit past noon, so we're going to take our break for lunch. You're free to go about your business for lunch. Just same rules apply. Please don't do any research, looking up of any names, maps, do any investigation on your own. Also, if you happen to see myself or any of the parties or anybody else involved in the case and we don't pay attention to you, that's because they've been instructed not to have any contact with you since you are the members of the jury. And we want to make sure that there's no appearance of any impropriety, okay? I'm going to have you all come back at 1:30. That'll give you a little time to get out of the building, try and find some place to eat, and then get back in to the building. We'll be ready to go sharply at 1:30. So once you all are assembled in the jury room, we'll bring you back in and get started, okay? Enjoy your lunch.
All right.
All right, have a seat. Before we adjourn for lunch, anything from the state?
Nothing from the state.
Defense? Just for planning purposes, roughly how many more witnesses this afternoon?
I plan on calling 2 witnesses this afternoon, the medical examiner and a firearms expert. And then from there, I plan to rest.
Okay.
And then obviously defense case.
All right. And we will be in recess till 1:30. All right, we're going to go back on the record because there were a couple of cases for arraignments this morning. This doesn't have to do with the trial.
Thank you. Calling case number 2025 CF00202880.
All right, we're back on the record. Both parties have returned. Been informed all jurors are present. Do we have anything that I need to address before we bring them back in?
Nothing from the state.
Nothing from the bench, Your Honor.
All right, let's go ahead and bring the jurors back in and we'll resume the trial. All right, seat. All right, ladies and gentlemen, welcome back. I trust you had enough time for lunch and that you all complied with the instructions of the court. You didn't do any research, looking up of anything, didn't do any investigation of your own, correct? All right, and did anybody associated with this case have any contact with you during the lunch break? No? All right, then we are ready to resume. State, you may call your next witness.
Yes, Your Honor. At this time, the state calls Dr. Marie Hansen.
Do solemnly swear or affirm testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you God.
All right, can you go ahead and state your full name for me and spell your first and last name for the court reporter, please?
Dr. Marie H. Hansen, Mariehansen.
State, you may inquire.
Thank you, Your Honor. Good afternoon.
Good afternoon.
If you could just introduce yourself to the jurors.
I'm Dr. Hansen. I'm an associate medical examiner at the District 9 and 25 Medical Examiner's Office. And I'm a forensic pathologist, which means I'm a medical doctor. I'm a pathologist. I did 4 years of anatomic and clinical pathology residency. And then I did a forensic subspecialty residency and have passed the national board exams and thus am board certified in anatomic, clinical, and forensic pathology.
Thank you, Doctor. And if you could just give the jurors a little bit of your educational background to hold your current position.
I have a BS in chemistry from the University of Wisconsin-La Crosse. I have a medical degree from the University of Minnesota. I have an anatomic and clinical pathology residency in St. Paul, Ramsey, and I have a forensic pathology residency in Miami, and I've been a practicing medical examiner since 1990.
Now, your current position in Orange County, how long have you had that position?
Since November of 2002.
And in that position, do you have to undergo periodic continuing education?
Yes.
And are you up to date with all the required continuing education?
Yes.
Now, as part of your work as associate medical examiner, is part of your job to perform autopsies?
Yes.
Can you describe to the jury what an autopsy is?
An autopsy is a gathering of history and then looking at a person, documenting the external surfaces of the body, looking for evidence of injury, evidence of natural disease, and evidence of medical intervention, and then continuing internally to look at the organs, looking for evidence of natural disease, evidence of injury, and taking specimens as appropriate for potential chemical analysis to help determine the cause and manner of death.
Now, in what circumstances is an autopsy conducted?
Under State Statute 407, any unattended death or any potential trauma, accident, suicide, or homicide, or an undetermined death would be reviewed. If somebody has been in an accident and has been in the hospital for a week, week and a half, they may have done enough documentation that we can tell why they died, and they may not need an autopsy. But in cases of homicide, almost everybody gets an autopsy.
And are you able to provide a rough estimate, I know you don't have the exact number, of how many autopsies you've conducted in your career?
Roughly an average of 250 to 300 a year since I've been practicing.
And that's going back to 1990?
Yes.
All right. I think you mentioned autopsies are a tool to determine the cause and manner of death. Can you just explain to the jury the difference between a cause of death and a manner of death?
A cause of death is a physical disease or a physical injury that causes a person to die. Manners of death are natural, due to natural disease, accident, most often car accidents or drug overdoses or drownings. Suicide, again, that can be drugs, that can be hanging, that can be shooting yourself, other inventive means as people invent, and homicide, deaths due to actions of another, as well as undetermined. Based on the information we have, we can't tell.
Now, when you conduct an autopsy, are they assigned specific case numbers?
Yes, they are.
And as part of your job duties, did you conduct an autopsy in case number ME 2022-909 on a person identified as Adreian Payne?
Yes, I did.
When was that autopsy conducted?
That was conducted May 10th, 2022, beginning at 9:15 in the morning.
Now, was that autopsy documented with photographs?
Yes, it was.
Have you had a chance to review your photographs or the photographs from that autopsy prior to today?
Yes, I have.
Let the record reflect I'm showing opposing counsel with the mark for identification as K.
You said K?
Yes, Your Honor. Now, as part of the documentation of an autopsy, is there typically a photo of just the deceased's face that's taken? It's like an identification photo?
Yes. A cleaned up picture of the face straight on for possible use in identification if it's necessary.
You may.
Let the record reflect I'm showing the witness with the mark for identification as states A. If you could just take a look at that. And is that the identification photo that was taken in this case?
Yes, it was.
And is that a fair and accurate depiction of the deceased as he appeared at autopsy?
Yes, it is.
At this time, the state offers into evidence what's been previously marked for identification as state A.
Any objection? No objection. What's been marked as States Exhibit K for identification is received into evidence without objection as States 11. You may.
Now publishing State Exhibit 11. And is this as we discussed the identification photograph taken of Adreian Payne in this case?
Yes, it is.
Now, were there other photos taken during the course of the autopsy showing wounds suffered by Mr. Payne?
Yes, there were.
Let the record reflect I'm showing opposing counsel with the mark for identification as States Composite L. Permission to approach?
You may.
Let the record
Yes, these are a selection of the photographs.
And are they fair and accurate?
Yes.
At this time, the state offers what's been previously marked for identification as State L and evidence.
Any objections?
No objection, Your Honor.
What's been marked as State's Exhibit L for identification without objection from the defense is received into evidence as State's 12.
Commissioner Publish?
You may.
Give you a laser pointer so you can walk us through these a little bit better. What are we looking at in this photo?
This is a photo of a front-on photo of Mr. Payne. You can see the head, the chest, and the upper arm. And in this particular picture, you can see the nipples are right and left, and he has a defect in his arm and a defect in his chest. And he has some abrasions from resuscitation artifact.
So you circled with your laser pointer in the middle of his chest. So that would not be something from the incident, something from attempted resuscitation?
Yes, this would be consistent with doing CPR.
And can you just point out in this photograph for the juror what you believe to be the wounds sustained in this case?
Somewhat in the shadows, but you have 2 wounds on the arm and 1 on the left chest.
Can you describe what we're looking at here?
This is the entrance wound in the arm, the exit wound in the arm, and the re-entry into the chest.
This is just the same wounds, but now with measure for scale?
Yes, we're measuring it to scale and the characteristics.
This is again a closer view.
Yes, this is a closer view of the wound through the arm.
What are we looking at here?
In this particular case, when we examined him in standard autopsy position with his hands at his side and his palms up, the wounds do not align, but if you lift the arm and turn it slightly, then the wound through the arm continues into the chest and continues down in through the body.
And this is just a photo of the left hand of the victim.
Yes.
Did you observe anything of note on the left hand?
No. We are looking for contusions, lacerations, chipping of the fingernail.
Is this the right hand?
Yes, this is one of the set of 4 for the right hand.
Did you observe anything of note regarding the right hand?
No.
What are we looking at in this photo?
This is a photograph of the projectile that we recovered from the right abdomen.
So during the autopsy, while you were performing the autopsy, is it correct that you actually withdrew this projectile from the body?
Yes, I did. And we're looking at a sort of cleaned up, this is the top, and you can see that it has gotten into a star shape instead of, so it's a deformed tip, and you can see it has a little bit of a copper backing. And we have it from different angles, so you can see the deformity of the tip, the core, and then the jacket. In the back, you can see that it's a yellow metal colored jacket.
Now, the photos that we just saw of the projectile, did you actually package the projectile up for evidentiary purposes?
Yes, we would package it place it in a small vial and put a label on it from the case, and then I'd seal it and sign the sealing of that.
Would you be able to recognize that from just the packaging, or would you need to open it?
Not from the outside packaging, because then it gets to law enforcement and they put it in multiple manila envelopes and
You may.
Showing the witness was compared to evidence at stage 8. You just take your time and open that up. Let me know when you've been able to get to a point where you can recognize that.
I can see and recognize what I signed.
So is this in fact the projectile that was removed from Mr. Payne during the autopsy by you?
Yes, it was.
You can remove it. Now, as part of your work conducting autopsies, is it helpful for you to use diagrams? And would that be helpful in describing the autopsy to the jury?
I believe it would.
Let the record reflect I'm showing opposing counsel for mark for identification as states M. Wishing to approach?
You may.
Let the record reflect I'm showing as a witness for mark for identification as states M. Let me know. Are those diagrams that done as part of the autopsy in this case?
Yes, they are.
At the time the state offers into evidence what was previously marked for identification as state M.
That's M as in like Mary?
M is in, no.
Okay. Just want to make all right. What's been marked as State's Exhibit M for identification without objection from the defense is received into evidence as States 13.
Mr. Publish.
You may.
What are we looking at here?
This is a diagrammatic representation of what you saw in the photographs, and I used a clear circle for the entrance and solid circle for an exit, and so the wound went from the arm, through the arm, misses the humerus, so it just goes through the soft tissue, then it goes into the chest, so that's a circle, and it goes diagonally, it goes through the lung, through the aorta, through heart and the other lung and through the diaphragm, and we recover the projectile, that's the X. Just on between the liver and the side of the abdomen.
We have a second diagram. If you describe this for the jury.
And in the standardized options that are available for me for the diagram, when you raise the arm, you can see that you can make it in an alignment so that it goes in a straight line through the arm, through the chest, and into the body.
Now, based on your experience as a medical examiner, with the positioning of the victim's arm based on the trajectory you were able to determine to be consistent with having your hand on a steering wheel?
It could be anything that puts the arm anterior and a little bit above. So it's in a line with the wound through the chest.
Would that also be potentially consistent with having your arm on like a window of a car or, window of a driver's side door?
Any position that's going to, any potential scenario that's going to get your arm up and a little bit anterior to the chest.
Now, based on your autopsy, were you able to determine a range of fire?
It appears to be a distant gunshot wound that's more than 2 to 3 feet away because there's no soot, there's no powder tattooing, and there's no the gunpowder that's coming out of the end of the gun to cause the explosion, to cause the bullet to go down the gun, comes out in a cloud with the gun, with the bullet. When it gets out of the gun, if you're close enough, it lands on the environment. And it was not on him.
So you're able to tell based on certain things like soot and other things if it's a close range gunshot. Is that fair to say?
That's correct.
But if it's beyond 2 to 3 feet, is that all just sort of the same category?
Yes. Once you get distant, once you have none of that, then it's at least 2 to 3 feet, and exactly how far may be determined by other investigational factors.
Now, as part of an autopsy, is a toxicology or drug screen run?
Yes.
Did the victim in this case have any drugs or alcohol in his system?
No, he did not.
And as part of your autopsy, do you weigh and measure the deceased?
Yes.
What was the weight of the deceased?
He was 247 pounds.
And how tall was he?
He was 80 inches or 6 feet 8 inches.
Now, in your autopsy in this case, were you able to determine a cause of death?
Yes.
What was the cause of death?
A gunshot wound of the arm and chest.
And were you able to determine a manner of death?
The manner of death is homicide.
Thank you. I don't have any further questions.
Ross.
Yes, Your Honor. Good afternoon. How you doing, Doctor? How you doing today?
Good afternoon.
Very good. Just briefly, you stated that this trajectory of the bullet wound was consistent with an arm being kind of raised in this type of manner?
Raised and a little bit anterior.
Okay. Something like, if I was to try to give you an example, can you see me? Would this be consistent?
Yeah, it's potentially consistent, yes.
Thank you. So it's, could this type of bullet wound be the result of someone attempting to raise their arm up potentially? You mean what I'm saying? Someone potentially raising their arm up? Could this type of interior?
If they're raising their arm up as the gun is fired, it potentially could get, could already have the arm up, or it could be in the process of raising it up. And when the bullet goes through the arm, that's...
Thank you. No further questions.
You redirect?
Briefly. So if an arm was raised as counsel just demonstrated, where would the hand be positioned based on the trajectory you were able to do in the autopsy?
Well, can be a number of potential. All I can tell you is the position of the upper arm relative to the chest. The hand would be out in front if you don't have, if somebody has their palm up, you could have your palm up, you could have your palm down, you could have your hands. In this particular case, it's a little bit better if it's twisted so that the thumb is down. Twist the arm to get in the in and out hole in the right line.
So obviously, just sort of anatomically, a person, when they have their arm up, they can only extend out this far, right? They can't go backwards at the elbow?
No, you can only go as far as your elbow will go.
So to be in the position that you were able to determine from the autopsy, if the arm was up, it couldn't be going back this way. It would be just facing this way or in this way, as I'm demonstrating.
Yeah, the arm would be in front because you can't make the hand go back without the arm being in a different position.
Thank you. I don't have any further questions.
All right, may the witness step down?
Yes, Your Honor. Thank you.
All right, thank you. All right, state for your next witness.
Yes, Your Honor. At this time, the state calls Kristen Killinger.
You solemnly swear affirm testimony you shall give shall be the truth, the whole truth, nothing but the truth, so help you God.
All right, go ahead and state your full name for me and spell your first and last name for me.
My name is Kristen Killinger, Kristen Killinger.
All right, state your main inquiry.
Thank you, Your Honor. Good afternoon.
Hi, good afternoon.
If you could just introduce yourself to the jury.
My name is Kristen Killinger, and I am employed by the Florida Department of Law Enforcement in the Orlando Regional Operations Center.
And what is your position with the Florida Department of Law Enforcement?
I am a crime laboratory analyst in the firearms section.
How long have you held that role?
I have been a crime laboratory analyst for about 5 years.
And have you had any other job titles, or have you had the same job title throughout your time there?
I have been at FDLE for 7 years. I was a forensic technologist in the trace materials section and also in the firearms section, and then I was promoted to crime laboratory analyst.
And in your current role, what are your job duties?
As a crime laboratory analyst, I primarily test firearms to see if they're functional or not. I will also do microscopic comparisons with fired ammunition components, such as bullets and cartridge cases.
If you could just give the jury your educational background to hold the current position you have.
I have a Bachelor's of Science degree in forensic science from the University of Central Florida. I also completed a 2-year training program in firearms identification.
Now, as part of your job with FDLE, do you have to have ongoing training to keep up to date?
Yes, I complete continuing education.
And are you up to date with all of the necessary continuing education to this point?
Yes.
Now, I want to take you back to January of 2023. Were you still employed with FDLE at that time?
Yes, I was a crime laboratory analyst then.
Did you become assigned to be the analyst in this case involving defendant Lawrence Dority, FDLE case number 2022-0506229?
Yes, I was.
So what were you asked to do in this case?
For this case, I received a firearm and a projectile, and I was asked to compare the projectile to the firearm if possible.
Were you also able to test the firearm to determine if it was functional?
Yes, I also did a functionality test on the firearm.
Can you describe to the jury what a functionality test is?
Yes, so when I receive the firearm, I will kind of look it over, document it, take notes on what I have, such as the make, the model, the caliber, the features that the firearm has. I will examine the firearm to make sure that it's safe for me to test fire. And then when I do feel like it's safe, I will take it onto our laboratory range. And in this case, I test fired it into our water tank, which is just a tank full of water. That way I could recover both the cartridge case and the projectile from the firing process.
And in this case, you yourself actually fired the firearm?
Yes, I did.
And was it functional?
Yes, it was found to be functional.
Now, regarding the projectile that you were sent, what were you tasked to do regarding the projectile?
For the projectile, I was asked to compare it to the firearm if possible to see if the projectile was fired from this firearm.
How was that done?
So I use a comparison microscope, which is just a microscope that has 2 stages, so I can view 2 things at the same time in the same field of view. So in this case, when I opened up the projectile, I documented what I had, and when I felt like I could move forward with a comparison, I took the bullet that I test fired into the water tank, and I compared it using my comparison microscope. I looked at the microscopic imperfections that are present from the firing process, and I compared the bullet that I received as evidence to the test-fired bullet that I fired into the water tank.
Now, these microscopic impressions, are they unique to each individual firearm? For like a fingerprint, is unique to an individual?
Yes, the firearm during the manufacturing process, the process of cutting the firearm to make it the shape that it is. There's rifling in the barrel that imparts the spin on the bullet for when it's traveling to spiral kind of like a football so it travels straight. The process of putting the rifling into the barrel is like cutting metal. And so there's microscopic burrs and inside of the barrel there's little metal burrs and flakes that are inside that will leave microscopic imperfections on the bullet during the firing process.
Your Honor, permission to approach with what's already in evidence as State 7 and States 8?
Okay. Okay.
Is that you have in front of you the firearm that you were sent to do the analysis on in this case?
Yes, it is.
And is in the manila package, is that the projectile that you did the analysis on?
Yes, it is.
And were you able to make any associations with that firearm and that projectile?
The projectile was identified to the firearm.
Now, when you say identified to, does that mean that that projectile that was removed from the victim in this case was fired by the firearm that you have in front of you?
Yes, it was.
I don't have any further questions.
Cross?
I have no questions for this witness.
All right, may the witness be excused?
Yes, Your Honor.
All right, thank you, ma'am. You can step down.
Thank you.
All right, state your next witness.
Your Honor, at this time, the state rests.
All right, ladies and gentlemen, the state has rested its case. There are some legal matters that I need to address outside of your presence, so I'm going to ask you to step into the jury room while I address those, and then when we're ready, we'll bring you back in, okay?
All right,
All right, have a seat. Any motions or matters that I need to address from anyone or any party as it relates to the state resting its case?
Yes, Your Honor. If I may have a moment, at this time, defense would like to move for a judgment of acquittal, and this is the basis for that. As relates to the charge, it appears that the state has charged my client, Mr. Lawrence Dority, with a second-degree murder with a firearm. Okay, carries a 25 life minimum mandatory, and as a necessary element, the state is required to prove an element that by an act imminently dangerous to another and evincing a depraved mind regardless of human life, Lawrence Dority did kill Adreian Payne. And during the commission of said offense, Lawrence Dority did carry, display, use, threaten to use, or attempt to use a firearm. And Lawrence Dority actually possessed a firearm with destructive device. Lawrence Dority actually discharged a firearm with destructive device. As a result of the discharge of the firearm with destructive device, death or great bodily harm is inflicted upon Adreian Payne. And viewing the facts in the light most favorable to the state of Florida, Your Honor, I believe the state has failed to establish by competent and substantial evidence in regards to the necessary element of an act being imminently dangerous to another and demonstrating a depraved mind. The reason why I make this position, Your Honor, is that by definition, just going to the jury instruction, an act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, number one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and, not or, and, meaning they have to also establish and is done from ill will or hatred or spite or an evil intent, and, not or, and, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, although it's not necessary for the state to prove the defendant had intent to cause death, the issue in this case is whether as it relates, if you're viewing the facts of this case in the light most favorable to the state, obviously we're raising self-defense, we haven't got to that point, but if you're viewing it in the light most favorable to the state, alternatively, the state would have to still establish during their case in chief that Mr. Lawrence Dority acted with depraved mind, right? And absent in this situation, the only alternative that would seem to support the facts as we are listed, or as we stand right now, the issue is whether Lawrence Dority did not have a depraved mind without regard to human life because he acted in the heat of passion based on adequate provocation. That's an issue in this case, Your Honor. So in order to find that he did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person. And a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. And there was no reasonable amount of time for a reasonable person to cool off. And a reasonable person would not have cooled off before committing the act that caused death. And that Mr. Lawrence Dority was in fact so provoked and did not cool off before he committed the act that caused the death of Mr. Adreian Payne. And that's what I believe the facts, at best, if we're looking at the facts of this case in the light most favorable to the state of Florida, they have not established a second-degree murder with a firearm. At best, in viewing the light most favorable to the state, what we have, because the facts support that this was a heat of passion, if we're viewing it in the light most favorable to the state, right? This is manslaughter. At best. Mr. Dority didn't have a relationship with Mr. Payne. He only knew of the man's name through his association with his girlfriend over the years. There was no evidence that he had a prior incident with him. any riff, any text, any call, any exchange, any prior situation. All you know, he's coming home and he's surprised by a person he doesn't have any affiliation with, and they have an altercation of words. He's feeling threatened. Well, from our position, we're saying he's feeling threatened. I know you haven't heard from my client yet, but the evidence still supports that there was an argument. And he went into his home. This is at 1:30 in the morning outside his house. And even by testimony of Ms. Tara Walker, she states that Mr. Dority asked, "Why are you here?" So what we have here is a spontaneous situation. But he didn't have time to cool off, because whatever the exchange was, it immediately resorted to Mr. Dority having to go back into his home and come back out and ask again, "Why are you here?" While his son is outside, his dad is outside, and they haven't made it safely into the home yet. So at best, Your Honor, this is not second degree, at this phase, this is not even second degree murder with a firearm. I would submit to the court. This is overcharged to begin with. Based on that, I believe that element, based on that lack of sufficient establishment of that necessary element, that you must give us a judgment of acquittal as it relates to second degree murder with a firearm.
Okay.
Your Honor, the defendant's actions in this case speak for themselves. He went after someone was not on his property but was parked down the street. He engaged that person in words. He then stormed into his house, armed himself with a firearm. During this time, he didn't, cool off, or he had certainly had time to do that. He then armed himself with a firearm. He came out. You heard the video of Tara Walker screaming for him, "Don't take your gun out, don't do this, Lawrence." And then he still, after all of that, in that circumstance, aims his firearm at the victim in this case and shoots and kills him. This certainly meets the elements of second degree murder. It doesn't require an intent to kill, but a depraved mind. Certainly, anytime you point a firearm and discharge it at a person in this circumstance, that shows ill will, hatred, spite, or evil intent. And again, that portion of the depraved mind is or. So it could be an ill will or a hatred or spite or evil intent. And then obviously shooting a firearm at another person is clearly indifferent to human life. So we've met the elements of second degree murder and ask that you deny the JOA.
Your Honor, may I add something briefly?
Good.
In light, regardless of what the state just mentioned, still sufficient facts that gives the fact finder a reasonable understanding of what Mr. Dority was placed in at that time, that situation. You heard from an expert that the trajectory of how the bullet went through his bicep to go into his chest cavity is consistent and could be because he was raising his hand, arm up. Now the issue is, why was he raising his hand up in the direction of where, if his thumb is down, Your Honor, he could have been holding his gun like this, or trying to. That's enough right there to not allow second degree murder with a firearm to proceed, Your Honor, if you're viewing the facts in the light most favorable to the state of Florida.
Wasn't there testimony that from one witness that his arms were up and he was in between the driver's door and the driver or the hood of the car? And that's a fact that is in the light most favorable to the state, that the arm is already up?
That doesn't negate that his hands is up. He could have had a weapon in his arm, in his hand as well.
Understood.
I understand Your Honor's position. Regardless of the fact there was no rift previous at the time of this situation. This is not something where he intended. I know he doesn't have to intend the outcome of death, but this is literally a heat of passion moment. It can be no other thing. And a heat of the passion killing by law is manslaughter. He didn't have time to cool off. Even the same witness that said Mr. Payne had his hands up also testified that Mr. Dority was in his house less than a minute minute at best, minute and a half at best. That's not time to cool off when someone's outside your house at 1:30 in the morning threatening you while your child and your father's outside. You just got to finish celebrating Mother's Day. You're on your way home, and unknown to you, someone's lying in wait for you. And when you ask why you're here, you get a threatening posturing response. 6'8", 247 pounds. That's adequate provocation. Thank you.
All right, I'm going to take the matter under advisement. There's one thing that I want to check on, and then I'll be able to rule on that issue. Okay?
Thank you.
All right, does the defense wish to present a case?
Yes, Your Honor. The defense would like to call Mr. Lawrence Dority.
All right, and any other witnesses?
With all candor to the court, I don't believe another witness is necessary. No.
Okay. All right, so a couple of things then, Mr. Dority. Your attorney has indicated that he's going to call you to testify. You understand that?
Yes, Your Honor.
All right, and he's indicated that he's making the decision not to call any other witnesses other than you for purposes of your case. You understand that?
Yes, Your Honor.
All right. Have you discussed that strategy with him?
Yes, Your Honor.
And are you in agreement with that strategy?
Yes, Your Honor.
Okay. So you understand that after you testify, there will be no other witnesses or no other evidence presented on your behalf? Is that correct?
Yes, Your Honor.
All right. Then the jury will have to make its decision based upon the state's evidence and testimony from their witnesses and from your testimony. You understand?
Yes, sir.
Okay. Now, have you had a discussion with your attorney about the pros and cons of testifying?
Yes, Your Honor.
Have you had a discussion with your attorney about the pros and cons of not testifying?
Yes, Your Honor.
Okay. You understand that if you take the witness stand and you testify, that you're going to be treated just as anybody else who takes the witness stand, meaning that the jury's going to get to assess your credibility just like they did everybody else's, and the same rules that apply to their testimony will apply to yours. All right. And you understand that you have an absolute right to remain silent if you want to.
Yes, sir.
Okay. And that if you were to exercise your right to remain silent, I would instruct the jury, as I did during the jury selection, that they are not to consider your decision not to testify against you in any way, shape, or form. You understand that?
Yes, Your Honor.
All right. Do you have any questions about your right to testify or your right to exercise your right to remain silent?
No, but is there a way that I could talk to my lawyer for a couple of
Certainly. Go ahead and talk to him, and then I'll follow up. All right, you've had a chance to continue or to consult with your attorney?
Yes, Your Honor.
Do you need any more time to do so with him?
Sir, is there a way I can take a bathroom break before
Oh, we're going to do that. Don't worry. And so, do you have any questions for your attorney or for the court about your right to testify?
No, sir.
Do you have any questions for me or your attorney about your right to remain silent?
No, sir.
All right. And you've indicated to me that you've had the opportunity to discuss the pros and cons of testifying and the pros and cons of exercising your right to remain silent, correct?
Yes, Your Honor.
All right. After having considered those, have you reached a decision in this case as to what you want to do?
Yes, sir.
Okay, can you tell me what decision you've reached?
I want the people to hear my story.
All right, so you want to exercise your right to testify.
Yes, Your Honor.
Has anybody forced you, threatened you, or coerced you in any way to make that decision?
No, sir.
Has anyone promised you anything to make you make that decision?
No, Your Honor.
And are you making that decision because you believe it's in your best interest and you want to?
Yes, sir.
Okay. And is there any other witnesses or any other evidence that you want presented to the jury other than your testimony?
There is one thing sure.
All right, have you discussed that with your attorney?
It's okay, Your Honor.
All right, so after consulting with your attorney about the issue that you were considering, you're advising me that you no longer wish to have any witnesses or evidence other than yourself testify, is that correct?
Yes, Your Honor.
Okay. All right, then what we will do is take about a 5 or 10 minute recess for everybody to use the restroom and whatnot, then we will come back and start with the defense case, okay? So we'll be in recess. All right, go ahead, have a seat. All right, does the defense wish to present a case?
Yes, Your Honor. May it please the court?
All right, you may call your first witness.
I would like to call Mr. Lawrence Dority.
All right, Mr. Doherty, if you'll make your way over to the witness box for me, please.
You solemnly swear or affirm to tell the truth, no truth, and nothing but the truth, so help you God.
All right, just have a seat. And state your full name and spell your first and your last name for the court reporter.
My name is Lawrence Dority.
Spell the first name and the last name.
Lawrence, Lawrence. Last name Dority, Dority.
Mr. Thompson, you may inquire.
Mr. Dority, how old are you?
I am 32.
You have any children?
Yes, I have 3.
What are their ages?
13, 8, and 2.
What do you do for a living?
I am a barber.
Have you lived in Orange County all your life?
Yes, sir.
Are you married?
I'm engaged.
I'm sorry?
Engaged.
Let's get right into it. Switch gears a little bit. You obviously been here and sat through this trial so far. You've heard a lot of things. And you actually live in this situation. You recall what happened on May 9th, 2022?
Yes, I do.
Did you explain to the court and the jury what happened?
Well, around 1:30 in the morning, me, my son, and my dad went to my house. My father was taking me and my son home. And as we arrived, I see the car parked at the corner of my home, and I automatically assumed it was Tara. So I thought it was weird that she was parked right there, because she would typically park in the driveway or in front of the house. And so I walk over there to greet her, to say, hey, you know, why are you parked here? And Mr. Payne gets out of the car. And when he gets out of the car, he's looking down at me. He has his hand in his waistband, and I can see like something silver sticking out on the side of his hip with his hand on it. And I asked him, what are you doing here? And he said, I'm not playing with you, I'll smoke you. I said, what? I threw my hands in the air and I started freaking out. My dad rolls down the window and asked me, is everything okay? And I told him, I don't know. So I go inside of my home. I retrieve my firearm so I could safely get my son in the house. And so as I return back outside, I see Mr. Payne has moved his car up even more, and he's gotten out of his car again. And so I'm standing in my driveway and I'm asking him, why are you here? What are you doing here? Why are you here? Can you please leave? Can you please leave? And he's just staring at me.
Okay. How tall are you, Mr. Doherty?
5'8",
How much do you weigh?
145 pounds.
Did you have a relationship with Mr. Payne? Had he ever been to your home before? Did you invite him? I need you to make an audible.
No, sir.
Did you have a relationship with him at all?
No, sir.
Did you invite him to your home? I'm sorry?
No, sir.
Out of all the years that you knew Miss Tara Walker, had you ever actually met Mr. Payne?
Like twice.
Was there any situation where you guys had a issue?
No. I just seen him one time. He showed up to my girlfriend's mother's Thanksgiving or something like that. He showed up unannounced, and I don't even recall the other time.
So getting back to May 9, 2022, when you came, why did you go back in the house? Why did you go in the house?
Because I thought was gonna die.
Why'd you feel that way, though?
He's outside my house. He's telling me he's gonna smoke me. I have my son outside. I have my father outside. He's there by himself. Nobody, I didn't.
How many shots did you fire? A moment.
I'm trying to go home.
Mr. Dority, when you speak into the microphone, let's just slow down a little bit. Let's try to take your time and make sure you speak into the microphone, okay?
What was the question?
At some point, you felt you went in the home and obtained your firearm. What were you thinking at that time?
I have to get my son safe. I didn't know. I just thought he was gonna kill me and my son and my father, and I didn't know. I didn't know what was gonna happen.
When you came back outside and you had this firearm, first of all, did you have a concealed weapon permit?
Yes, sir.
So had you taken self-defense classes before?
Yes, sir.
When you came out, did you have any additional words or anything was said by you at that time?
Yes.
What was that, if anything?
I said, "Can you please leave? Why are you here? Can you please leave? What are you here for?"
And what was the response that you got?
He didn't say anything. He was just staring at me.
And then at some point, you felt the need to discharge your weapon. How many shots did you take?
One. I saw him. I was saying, "Why are you here? You need to leave. You need to leave. You need to leave. Why are you here?"
How were you saying it? Were you saying it softly, or how did you say it?
Like, "Why are you here? What are you here for?"
Were you talking to him?
I don't know.
Could he hear you?
Yes,
How do you know he could hear you?
because he was staring at me, and it wasn't far. It's like from here to the end of the courtroom. Like, it wasn't far.
When you came out the house, or at the time when you took a shot?
I mean, I was in my driveway the whole time.
Did Mr. Payne appear to reach for something, or
Yes. When I was saying, "Why are you here? You need to leave. You need to leave. Why are you here?" I seen him going like this, putting his hand up, like he's raising a gun towards me. And I shot one time, and I called the police, and I put my son in the house.
before we get to that point, at some point, you stated when you went in the house and came back out that his vehicle was even closer than it was at first when you first encountered him. Is that true? Is that a yes?
Yes, sir.
So after the fire, after you discharged your weapon, you called 911? I need you to speak into the microphone.
Yes, sir.
Did you remain at the scene?
Yes, sir.
Did you cooperate with law enforcement?
Yes, I did.
Did you provide a statement to law enforcement?
Yes, I did.
Even after they give you Miranda warnings, you gave a statement, right?
I was never read any Miranda rights.
You provided a statement, right?
Yes, I did.
Is there anything else you want the jury to know that you hadn't said?
before I got up here, I thought I knew what to say exactly, you know, but I don't. It's just no.
I don't think I asked you this, but at that time, how old was your father?
60, 62.
And how old was your son at that time?
8, 9.
How old? I'm sorry.
8 or 9, 8.
Were you intoxicated?
No. I was with the police for 13 hours.
None of the officers assumed or speculated that you were intoxicated?
No.
Now, at the scene of this incident, Tara Walker was present, right?
Yes, sir. Afterwards.
Did you see her go into the vehicle that Mr. Payne was in?
While I was on the phone with the police, I put my son in the house. I'm on the phone with the police. And I saw my father go over to Mr. Payne to see if everything was okay. And I can hear him telling her, find a piece of plastic so I could try to stop the bleeding. And I see her go through the back seat. She goes through both of the back seats. She goes through the front seat. She goes to the glove compartment, and she just runs. She runs to the other side, and we didn't see Tara until the police arrived.
Do you know, or did you see anyone else that may have had any relationship or affiliation with Tara Walker arriving on the scene?
Yeah, her brother and her father came, and I was just so confused because they had my son and my father and me like chambered away, and she's just frolicking around, calling her friends and calling her family.
Sustained.
You know, and I was just confused.
Mr. Dority, I'm going to ask you this question. Did you see a firearm in the hand or in the possession of Mr.
Yes.
Did you feel like your life was in danger?
Yes, me, my son, and my father.
No further questions, gentlemen.
Cross.
Good afternoon, Mr. Dority.
Mr. Smith.
So I want to go back to several things that you said in your direct testimony, but first I want to start out with, you said in your direct examination testimony that you gave a statement to law enforcement after this, right? Is that correct?
Yes, sir.
Okay. And you say in your testimony to this jury that you were never read your Miranda rights. Is that right? That's what you just said to your attorney?
From what I can recall.
Well, you didn't say you didn't recall, right? What you said to your attorney was that you were never read your Miranda rights. Is that right?
Yes, I did.
Okay. I'm going to direct you to page 12 of the transcript of your statement that you, with the detective in this case, beginning at line 5.
Really quick, can I say something?
I'm going to approach and I'm going to show you what I'm talking about.
Okay.
I've got to lay this for the record.
Okay.
Okay? I'm going to show your attorney. Permission to approach?
You may.
I'm going to just let you read along. So this is where I read from, but I'm going to read this. You said
This is
something.
the interview?
Yes, this is the interview.
Okay. I was in response. I was talking about when they initially arrived to my home.
Okay. But just
Not
to be
this.
clear, what this says is, okay, well, let me do this. I want to read your rights, okay? And you say, and the detective says, and then we can talk about that after, okay? And you say, okay, buddy. And then detective says, so you have the right to remain silent. You say, and then anything you say can be used against you as evidence. Yes, sir. You're entitled to talk to an attorney now and have him present now or any time during question. Do you understand? Yes, sir. If you cannot afford an attorney, you can be provided with one without cost. Do you understand your rights? And then you said, after being read that, in the transcript of your interview with the detective, yes, sir. So you were read your Miranda rights, correct?
Yes, I was not read them initially when I was placed in handcuffs, which I was referencing to.
Okay.
Not my interview.
Your testimony to this jury not 10 minutes ago was that you were never read your Miranda rights. Is that correct? Never. That's what you said. That's not true, is it?
I was read my Miranda rights in the interview room.
Okay. Thank you. Now, another thing that you just said that I found to be interesting is you said that when you came back out of your house, after you'd gone in the house and armed yourself with a firearm, you said that you came back out and you said, can you please leave? And you were speaking sort of calmly to the jury in a sort of meek tone that you're speaking today. Can you please leave? And this is after you came back out, after you armed yourself with a firearm, you're asking him, can you please leave? Is that right?
Correct.
Okay. So I want to direct you, and I'll let you look at it. I'm going to read it again. I'm going to tell your attorney to, this is your interview with Detective Gilberti. This is on page 50, beginning at line 16. This is going to be line 16 through line 23. Permission to approach.
You may.
I'll let you look at this and then I'm going to read it out loud because this is the opposite of what you just said. Starting in line 16, I'll give you a moment to read through line 23. All right, so your testimony on direct examination was that you were just asking him to please leave when you came out with the firearm, right?
Correct.
Okay. But what you said to the detective in your interview was, and I'll begin on line 16, a detective, like when you came back out with the gun and he was still in his car.
Best evidence, Your Honor.
Response.
This is impeachment.
Overruled.
Yeah. Like when you came back out with the gun and he was still in his car, did he say anything to you? No. Well, sorry, Mr. Dority, your response was no. The detective says, was there any communication? And Mr. Dority, your response was, I didn't communicate with him, I shot him. That's what you told law enforcement the day that this happened in your interview, right? You didn't say, could you please leave? You just shot him. Is that right?
That's what I had said in the interview.
Right. Okay. So I want to go back a little bit. This afternoon, the afternoon going into the early morning that this shooting happened, you were at your father's house, right?
Correct.
Okay. And you had been drinking at your father's house?
Earlier that day.
And you had been drinking some shots of Casamigos at one point in the afternoon, right?
Earlier that day.
Okay, but earlier that day, you had been drinking shots of Casamigos, correct?
Correct.
Overruled.
Earlier that day, you had been drinking shots of Casamigos, correct?
Correct.
Okay. And to be clear, where was your vehicle when you came back to your house?
Parked in my driveway.
Okay. And so your father drove you to your residence from his house, right?
Right.
But it's a close distance, right?
Yeah, I could have walked.
Okay. All right. So I want to talk about some other things that you said in your direct testimony. You were very clear in your testimony 5-10 minutes ago when your attorney asked you, did you see a firearm, right? You said, yes, I saw a firearm. That was your testimony 10 minutes ago, right? Correct?
Correct.
Okay. Now, I want to take you again to your interview with the detective in this case. This time I'm going to direct you to page 35 of the transcript of the interview. Now, on page 35, do you have the transcript, or do you need to see it?
I have a copy of it, but I don't know exactly.
Sure. I'm on 35 at line 25 and 36 at line 3. All right, so Mr. Dority, I'm going to read from this transcript starting at line 25 on page 35. Detective Gilberti, this is his question to you. Okay, did you ever see a gun? Mr. Dority, I cannot say I necessarily saw a gun, but if you're giving me this gesture, I've taken concealed weapons classes. I've taken defense classes before. If somebody approaches me like this, and that's your answer. So you cannot definitively say and honestly say to this jury,
Objection, Your Honor. Objection, Your Honor. Argumentative.
Sustained.
you cannot say definitively that you saw a gun, can you?
Objection, Your Honor. Same objection. Argumentative.
Sustained.
Judge, can we approach?
Come on.
So today in your testimony, you mentioned that you saw a shiny object when you first approached the victim's vehicle, right?
Yes.
Is that correct?
Right.
Okay. But you never said anything at all in your initial interview with law enforcement about seeing this
Objection,
shiny
improper
object.
impeachment.
Overruled.
You never said anything at all about the shiny object then, right?
When
When you had your interview with law enforcement at the interview room.
I had been waiting and sitting in the back of a police car for 7-8 hours. I was in the interview room for 6-7 hours. I hadn't slept. I was beyond tired, and my recollection of what happened could have been maybe, I don't.
Okay, so you didn't say it then, but you're saying it now, right?
I said it.
Okay. Now, you mentioned in your direct testimony that you were concerned for your son and for your father who were present at the time of the shooting, right? Is that yes?
Yes, sir.
Okay.
I apologize.
But even by your own telling, there was never any threat by the victim made to your son, right?
Objection, argumentative, Your Honor.
Overruled.
There was never any threat made by the victim to your son, right?
Correct.
Is that correct?
I said correct.
And there was never any threat made by the victim to your father, right?
Correct. It doesn't have to be made to them, though.
Okay. Now, you would also agree that where the victim was parked was not your property, right?
The neighborhood is considered my property. I don't own the neighborhood, but it's my dwelling. That's where I live.
Okay. But to be clear, Mr. Payne never set foot in your house, right?
No.
He never stepped foot on that piece of grass in front of your house.
He may have.
Okay. Do you remember previous testimony in a hearing? In a courtroom like this?
Yes.
Okay. I am going to direct and show opposing counsel transcript of a previous hearing.
I don't know what he did when I went in the house.
Okay, I'll direct a question to you in a moment. I'm showing opposing counsel the transcript, page 156. Okay, so my question was, at the time, was that area that he parked, is that your property?
No, sir.
Okay, so you're saying it was not your property. You agree?
It wasn't my... I don't own the land. I don't own it. I was a tenant there.
I understand that. But you leased the property, presumably?
Yes, sir.
Okay. And with that lease, it doesn't entitle you to the entire neighborhood, correct?
It's a private neighborhood.
It's a private... Is there a gate to get in?
There was until it was destroyed.
Okay, so at the time of this, you could just drive into the neighborhood, correct?
Yes, you could.
Okay.
It's still a private residence.
And that area that the victim was parked, that's not included in your lease, correct?
Correct.
Now, when you went inside your home to arm yourself with a firearm, in this case, the victim didn't follow you, right?
No.
He stayed by his car.
Correct.
And so you went in. You would have had time at that point to call 911 if you deemed it necessary?
Correct.
But you didn't do that, did you? Did you?
I didn't think it was necessary at that moment.
Okay. What you deemed was necessary was to get your firearm, go outside, and kill it, right?
No.
So that's what you did.
It's not subsequently what happened.
So you went in the house, right?
Correct.
You armed yourself with a firearm.
Correct.
You went back outside the house.
Correct.
You aimed. Before you shot, you aimed. Yes?
Correct.
And then you shot Adreian Payne.
After I asked him to leave several times.
And again, we already went through your original transcript, but what you previously said was you didn't communicate with him, you shot him.
You have
right?
audio recording of it.
Okay. I'm asking the questions here. You said, in what we've already established in your previous transcript, you didn't communicate with him, you shot him, correct?
If you say so.
I mean, we can look at it again. Do you need to look at it?
No, I looked at it already. You already showed me.
Okay, so you would agree. You said you did not communicate with him, you shot him, right?
Correct.
All right. I don't have any other questions. Thank you.
Redirect.
Yes, briefly, Your Honor.
Hello.
Your interviews with law enforcement was recorded, right?
Correct.
Okay. So your conversation that you had with law enforcement that spanned over several hours could be shown to the jury, couldn't it?
Yes, sir.
Okay. At the time when I asked you, had you been given Miranda warnings, is it your testimony that you thought when you were first encountering law enforcement, they never asked you a question as far as Miranda?
Correct.
But at some point throughout the time that you were in custody, You were at some point in the interview provided with Miranda warnings?
Yes, and I feel like, he tried to trick me with that question, which is how the answer came out like that.
And again, you seen a video of outside, right?
Correct.
Could you hear the verbal altercation that you had with Mr. Payne?
Yes.
So you did, in fact, communicate
Yes, I
to
did.
Mr. Payne. Right? In fact, you heard the testimony of Ms. Tara Walker, too, today, right?
Correct.
She also testified that you asked, why are you here, right?
Correct.
So you did communicate.
Correct.
Is it that you was probably confused when law enforcement was questioning you, possibly?
Yes.
Okay.
I was beyond exhausted. I was tired. I could barely keep my eyes open. It was like 10 o'clock the next day. I hadn't slept.
And again, that interview was recorded, right?
Correct.
Video recorded?
Yes, sir.
Okay. No further questions, Your Honor.
All right, sir, you can have a seat back at counsel's table. All right, defense, call your next witness.
Your Honor, defense rests.
State wish to present any rebuttal evidence?
No, Your Honor.
So state rests.
State rest.
All right, let me have counsel approach. All right, ladies and gentlemen, the state and the defense have both rested their cases at this point. There are some other legal matters that I need to take up outside of your presence, and then we will have to be working on the charge conference, which is the jury instructions that will be sent to you and the verdict forms that will be sent to you. And so what I'm going to do is, while we work on that, the remainder of this afternoon, I'm going to send you all home a little early, okay? When you come back tomorrow, we will have those instructions ready. There will be copies and everything ready for you all, and so that we will be ready to go when you get here. At that point, I will give you all the closing argument instruction. The attorneys will make their closing arguments to you, and prior to lunch, you will then be out to deliberate. What I will ask for you all to do tonight before you leave is I'll have the court deputies give you the lunch menu for tomorrow. Make a choice of what it is that you would like for lunch so they have it, so they can order it so that it'll be available in the jury room for you around 11:45 noon tomorrow by the time you get back there or when you're out there, back there deliberating, okay? Also, make sure you get the number from the sheriff's deputies before you leave so that you can share that with your loved ones or family members who may need to get a hold of you, because you can expect that sometime mid to late morning you will be in the jury room deliberating the verdict in this case, okay? Any questions before we break for the night? All right, same rules apply. Obviously, please don't do any investigation, any looking up of anything on your own. And I'll ask you all to come back tomorrow morning at 9 o'clock, okay? I only have one thing else on my docket in the morning. It's a very brief matter, and I will have that done relatively shortly, so we should be able to get started right away, okay? So I will make sure you get the menus for them. Once you get the menus, go home for the night. We'll see you back tomorrow at 9, okay?
That's for me.
All right, go to have a seat. All right, the close of all the evidence, any motions or matters that I need to address from either party?
Oh, yes, Your Honor. I would like to renew my motion for judgment of acquittal as it relates to the issue of, I don't believe the state has rebutted the defense's claim of self-defense. And so I would like to state, just as a matter of course, in viewing the facts of the case in the light most favorable to the state, they have failed to, like, once the defendant introduces any evidence of self-defense, the state bears the burden of proving beyond a reasonable doubt that the defendant did not act in self-defense. And that's Bozeman v. State, 714 Southern 2nd, 570, Florida First DCA case in 1998. And it's on point here. The state didn't provide any rebuttal evidence in regards to a claim of self-defense, so we would argue that at this point, the judgment of acquittal would be warranted, at least as it relates to elements of second-degree murder with a firearm. I do understand that this is a factual issue that is usually more properly presented before a jury, but pursuant to Martinez v. State, 981 Southern 2nd 449, a Florida Supreme Court case of 2008, if the state fails to carry this burden of rebuttal in regards to not proving beyond a reasonable doubt that the defendant did not act in self-defense, the defendant is entitled to a judgment of acquittal. It even goes so far as to a Florida Supreme Court case of 1974, Lynch v. State 293 Southern 2nd 44, to defeat a judgment of acquittal in a self-defense case, the state must present evidence from which a reasonable jury could conclude that the defendant was not in reasonable fear of imminent harm, or the force used was not necessary or was excessive, or the defendant was the aggressor, or the defendant did nothing to retreat. The judgment of acquittal must be granted if the defendant presented a plausible case of self-defense and the state fails to rebut it with competent, substantial evidence. That's what we have here, Your Honor. Mr. Dority is charged with second-degree murder with a firearm. The defendant has presented credible evidence that the defendant acted in lawful self-defense pursuant to Florida Statute Section 776.012 and or 776.013. Under Florida law, once a defendant introduces any evidence of self-defense, the burden shifts to the state of Florida to prove beyond a reasonable doubt that the defendant did not act in self-defense. So with that being said, when viewing the evidence in the light most favorable to the state, they fail to provide competent or substantial evidence from which a reasonable jury could find that the defendant was not in reasonable fear of imminent bodily harm, that the defendant's use of force was unnecessary or excessive, or the defendant was the initial aggressor, or the defendant had a legal duty to retreat and failed to do so. In this situation, therefore, no reasonable jury could lawfully reject the defendant's theory of self-defense and still find beyond a reasonable doubt him guilty. As such, pursuant to Lynch v. State, the state has failed to meet its burden under the applicable standard of law, case law precedent, and therefore judgment of acquittal is proper. Thank you.
Dave?
Judge, I think there's a misconception. Obviously, just because the defendant testified doesn't mean that I have to then put on a rebuttal case, which is sort of what it sounded like opposing counsel was saying. Obviously, the defendant's story is rebutted by the evidence that was already placed on by the state, particularly Tara Walker and the video that was presented into evidence where you can hear the encounter just before the shooting and the shooting itself. She stated that the defendant, came out and that he fired, not having been, there was no threats made in his direction, that the victim didn't have a weapon, there was no weapon found in the vehicle. All of this, a jury could find beyond a reasonable doubt that he did not act in self-defense. Further, by the defendant's own admissions in his statement, just because the defendant says it's self-defense doesn't mean it is. So while he characterized what he did on that day as self-defense, it certainly wasn't. If you look at the applicable law and the instructions that you're going to give the jury, that it has to be reasonable, and it's both an objective and a subjective standard. So the defendant himself has to reasonably believe that his actions were justified and necessary in the circumstance, and even if you found that that was met, objectively, a reasonably prudent and cautious person in the same or similar circumstances would have to feel the same. And his actions of going back in a house, arming himself, coming back and shooting somebody, that is not justified. That's not self-defense. So even if you just took his own words, he's not rebut the state's case that he was not acting in self-defense in this circumstance. I would point to, obviously, just going to the other point regarding the JOA, that I'd point to Mackey versus State. It's a first district case, 277 Southern 3rd, 762. I say it's a depraved mind, regardless of human life, second-degree murder may be established by competent, substantial evidence that the defendant acted with ill will, hate, and spite, and that the circumstances surrounding the fatal act can prove the ill will, hate, or spite. In this case, you have the circumstances around it that show it. You don't have to have an express testimony or express statement that there was malice or evil intent, spite. You can look at the circumstances as we have here, and we can clearly see that this defendant was not acting in self-defense. So I ask that you deny the JOA.
Your Honor, briefly, I'll just add, these facts supports the judgment of acquittal. 1:30 in the morning, size difference, uninvited. You can infer that Mr. Payne wasn't coming over to wish him happy birthday. Okay? Again, had no relationship with Mr. Dority. His girlfriend told him not to come. Despite doing that, he still came. Even after Mr. Dority went into the house, just think about that for a second. If someone is objectively questioning why you're present at a certain hour at someone's home, place of residence, your castle, no, he's not inside the home, but he's lying in wait as he comes home. Very close proximity to where he lays his head, where his child lays his head. His father is in his 60s. His son is 9 years old. He's questioning why you're here. And the threat of posturing yourself as if you have a right to be at someone's home without an explanation, that placed Mr. Dority in fear. And if Mr. Payne didn't want any problems, if he didn't want any smoke, any issues to occur, when Mr. Dority retreated into his home, because he didn't just walk up to him with a firearm. He didn't walk up to him wanting a confrontation. He thought it was Tara Walker in that vehicle. She had been driving that vehicle for several months. Unknown to him, it was someone else who rolled the window down, hopped out the car, and surprise, this is not what you want, little man. Yes, it is an issue of what was said. Nobody in this room was there other than Mr. Dority and Mr. Payne. Tara Walker wants you to believe that she was there when it initiated. She was not. She admitted he was already there. She claims to have been on the phone with him and heard some chatter, but she can't say conclusively what was said. But if you didn't want any problems, reasonable people would acknowledge the fact that when someone goes into their home and you are now on notice that you are not wanted there, he could have left. But instead of him doing that, what did he do? With his 6'8" frame, 247 pounds, he moves up closer to the man's driveway. That places somebody in fear at 1:30 in the morning. Coming home and somebody you don't have a relationship with waiting on you, and you ask them why you're there. By the time you go in that house, he needs to be gone when you come back outside. That didn't happen here. This is common sense. The way the legislature works with these gun laws, this is not like a random shooting that happened in New York, just shooting bystanders. Even Governor DeSantis is pro-guns. He removed the need to have a concealed weapon permit. For situations like this, he's at his home. Asked him to leave. Even Tara would agree. He asked, why are you here? All this chatter about you told law enforcement you didn't communicate. The video itself shows there was communication going on. Tara herself said that it was communication going on. Whether he was giving Miranda or not doesn't matter. He gave a statement. So that don't even matter. Your Honor. At the very least, before we let this get to the jury, if you find that it needs to get to that point, which I submit to you, you should not. But if you find it that it's necessary to let the jury deliberate, they should not be deliberating over second-degree murder with a firearm. That is an overcharge. That is not what we have here, by any stretch of the imagination. Not that. Maybe negligent homicide, maybe. Something definitely lesser than second degree should go to this jury. Not second degree murder. He shouldn't be facing life for that. That's not what the people of Florida support. The public would not be...
Judge, I'm going to object to the improper argument talking about what the people of Florida would support.
Staying, let's confine our argument to the facts and what the standard is for a judgment of acquittal at the close of the case.
I have nothing else, Your Honor.
All right. Based upon the evidence that's been presented to the court and the standard that applies at the close of all the evidence, the court does find that there is sufficient evidence to allow the case to continue to the jury, so the judgment of acquittal will be denied. Counsel for the state provided a copy of, or a draft of verdict forms and a draft of jury instructions to the court. Mr. Thompson, did you get a copy of those?
Yes, Your Honor, I did.
All right. And did you have a chance to review them with your client?
Not thoroughly with my client, I did not.
Do you have a copy of them on your computer that you can pull up? Okay.
Oh, yes, Your Honor, I did send this to him.
Okay.
We discussed.
All right, Mr. Dority, did you get a copy of that was sent to you by your lawyer? Yes, Your Honor. Was that a yes?
Yes, sir.
Okay. And did you have a chance to read through it?
Yes, Your Honor.
And did you and your attorney have a chance to discuss it?
Yes.
Okay. What I'm going to do is you have a copy of it now up, Mr. Thompson, so you and your client can see it?
Yes, Your Honor.
State, have yours up?
Yes, Your Honor.
Okay. So we'll just kind of go through it. I assume nobody has any objection to the caption?
No objection.
No objection from the state.
All right. And then there's the standard instruction on final instruction to the, or introduction to final instructions. Anybody have any objection to that?
No objection, Your Honor.
No objection.
All right. The next standard instruction has to do with the statement of the charge. Any objection?
No, Your Honor.
No, Your Honor.
Next instruction is the introduction to homicide instruction. Any objections?
No from the
No
state.
objection.
All right. The next one is justifiable homicide instruction. Any objection?
I don't have that in that order. So my page 5, it goes from excusable homicide and then into second-degree murder on page
Well, the one you sent me had an introduction to homicide instruction, then a justifiable homicide. It's probably part of the introduction to homicide.
Okay.
If you go down
Yes.
in there,
I see, yes.
I break it out as a separate instruction.
Okay.
I have the same thing.
Okay, so, but it's part of the introduction to homicide, but it's a separate little subsection that says justifiable homicide. Nobody has any objection to that.
No objection, Your Honor.
No from the state.
And then right under that is another subsection for excusable homicide. Any objection to that?
No objection.
No from the state.
All right, and then the next instruction is the second-degree murder instruction. Take a look at that. Tell me if anybody has any objections to the second-degree murder instruction.
No objection other than what's previously been argued.
I understand that you're reserving your right on the judgment of acquittal.
No objection from the state.
All right, and then the next instruction is the standard instruction on aggravation of a felony by carrying a firearm. Any objections?
No objection, Your Honor.
No objection from the state.
Next one is the standard instruction on possession of a firearm, discharge, and causing death.
No objection.
No from the state.
All right, the next one is the standard instruction on when there are lesser included crimes.
No objection.
No objection from the state.
All right, and then the lesser included crime is defined as manslaughter. Any objection to that instruction?
No objection.
No objection from the state.
All right, and then there is a repeat of the aggravation of a felony by carrying a firearm as it relates to the manslaughter. Any objection to that instruction?
No objection.
State.
No objection from the state.
All right, and then there's the justifiable use or threatened use of deadly force instruction. Take a look at that.
I have this highlighted. I don't know, there's different language, and the defense has to affirmatively state what, if they're seeking the part B, which I put in as aggravated assault, just based on prior arguments that they had made at the stand your ground hearing. That would sort of be my anticipation of what they would be asking for regarding the forcible felony. But if that's not what they're asking for, obviously we'll need to go in and, change that.
That's why I'm asking the defense to take a look at it and see if they have an objection or if they're asking for any changes.
No objection, Your Honor.
Okay. I assume the state has no objection.
No objection.
All right, then we get to the standard instruction on plea of not guilty, reasonable doubt, and burden of proof. Any objection to that?
None from the state.
No, it looks standard. No objection.
Let me get to the standard weighing the evidence instruction. Paragraphs 1 through 5 were included, and then I added the sixth, or there is a sixth paragraph added that included making inconsistent statements in court. Does anybody believe that the other 4 paragraphs apply? I don't think that they do, but
I believe the 6 that we have are appropriate.
defense?
I agree, Your Honor. I don't see what the other ones were. That's all I received. I don't receive the other ones.
Well, the other ones usually have to do with reputation and for dishonesty, criminal convictions. None of that kind of stuff came out.
I have no objection.
All right. And then the next standard instruction is the defendant's statement instruction.
It's missing the caption, I think, maybe, at the top.
Where it says defendant's statement?
Yes, Your Honor.
I have it on my copy.
I don't have it on mine. Well, I have it. The next page has it.
All right, there you got it. Any objection to that instruction from either party?
Not from the state.
No objection, Your Honor.
Okay, that gets us to the rules for deliberation, standard instruction. Any objections?
None from the state.
None from defense.
All right, and then the standard instruction for cautionary instruction, any objection?
None from the state.
None from defense?
Standard instruction on verdict, any objections?
None from the state.
No objection.
And then the standard instruction on submitting the case to the jury. Any objections?
None from the state.
No objection from defense.
All right. And Mr. Doherty, you've had a chance to go over this as we've gone through it here in court. You had a chance to go over it previously with your attorney. Is that correct?
Yes.
All right. And you agree with the choice of lesser included offense for being manslaughter?
Yes.
Okay. And are you in agreement with the instructions as your attorney has indicated? And then for purposes of closing, I assume, counsel, you're going to again concede elements of the offense or the lesser included offense, but as part of your self-defense claim?
Yes, Your Honor.
All right. And so, Mr. Doherty, as you indicated to me previously, you understand that that's the strategy that you and your attorney have agreed upon for purposes of this case? All right. So you understand that during the closing argument, as he did during the opening argument, he may be making concessions that the shooting happened, but his claim is that it was self-defense. You understand that? And you're in agreement with that strategy?
Yes, sir.
All right, so the verdict forms then are finalized. I will have my assistant make multiple copies. I'll make 2 for you all, so you all each will have a hard copy. I'll make a copy for the state. Rebecca, do you need one? All right. I'll make 1 for the clerk, so that's 4. And then we need 8 for the jurors, so I'll make a total of 13 so that I have 1 to read from. I'll make those copies. I will make sure that I have them all here. We'll disseminate them for the jurors in the morning, and I'll have copies for you all ready when we come into court, okay?
Thank you, Your Honor.
All right, so, and then as far as the jury verdicts go, you got a copy of those, Mr. Thompson?
Yes, Your Honor, I do.
All right, and you forwarded that to Mr. Doherty as well?
Yes, Your Honor, I do.
All right, Mr. Doherty, did you get a chance to look at the verdict forms? Okay. All right, the verdict form as to count 1 gives the jury 3 options: second-degree murder, the lesser included offense of manslaughter, and not guilty. Any objections to that verdict form?
None from the state.
No objection from defense.
All right. And then there are 4 special findings based on the way that the case was charged. The first special finding has to do with possession of a firearm or no possession of a firearm. Any objection to that special finding?
None from the state.
No objection, Your Honor.
The second special finding has to do with discharge of a firearm or no discharge of a firearm. Any objection?
None from the state.
None from defense.
The third one has to do with discharge causing death or not causing death. Any objections?
None from the state.
None from defense.
And then the fourth special finding has to do with personally carrying, displaying, using, threatening to use, or attempting to use a firearm or not. Any objections?
None from the state.
No objection.
All right, so the verdict forms and special findings are in order, and I will have my assistant make 1 copy of those for the jurors. All right, anything else that I need to address from the state or defense before we adjourn for the evening?
Nothing else from the state. I know some judges have different, when you're saying what you're going to send back with them, the jury room, some judges will send everything back. Some judges don't want to send the firearm back. I don't know what you were planning to do regarding the firearm and the defense had a position.
Right. I know that sometimes in the past they've done that where they've rendered them safe and sent them back, but if you all aren't comfortable doing that, then we'll send everything back with the exception of the firearm. I'll let the jury know if they want to see the firearm, that they can ask me with a note to see it.
Understood.
Okay?
Yes, Your Honor.
All right. Anything else from the state?
Nothing further from the state.
Any further from the defense?
Thank you.
All right, then we will be in recess on this case till 9 o'clock tomorrow morning.
Thank you, Your Honor.
All right.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. So rise up now, it's our time to shine. Together we'll write a new paradigm. You paradigm, you paradigm. Whoa, whoa. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. So rise up now, it's our time to shine. United and free. Together we'll write a new paradigm. United and free. United and free. United and free.